ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಹೊಸ 3 ಅಪರಾಧ ಕಾನೂನುಗಳ ಸಂಬಂಧವಾಗಿ ನಮ್ಮಲ್ಲಿರುವ ಕೌಶಲ್ಯ ಸಾಮರ್ಥ್ಯವನ್ನು ಹೆಚ್ಚಿಸಿಕೊಳ್ಳುವ ನಿಟ್ಟಿನಲ್ಲಿ ಕರ್ನಾಟಕ ನ್ಯಾಯಾಂಗ ಅಕಾಡೆಮಿ ಆಯೋಜಿಸಿರುವ 3 ದಿನಗಳ ದೃಷ್ಟಿಕೋನ ಕಾರ್ಯಕ್ರಮದ 2ನೇ ದಿನದ ವಿಚಾರಣಾ ಸಂಕಿರಣಕ್ಕೆ ಆಗಮಿಸಿರುವ ಎಲ್ಲ ಗೌರವಾನ್ವಿತ ಪ್ರಧಾನ ಜಿಲ್ಲಾ ಮತ್ತು ಸತ್ರ ನ್ಯಾಯಾಧೀಶರು, ಜಿಲ್ಲಾ ನ್ಯಾಯಾಧೀಶರು, ಹಿರಿಯ ದಿವಾಣಿ ನ್ಯಾಯಾಧೀಶರು ಹಾಗೂ ಸರ್ಕಾರಿ ಅಭಿಯೋಜಕರಿಗೆ ತುಂಬ ಹೃದಯದ ಸ್ವಾಗತ. I welcome our resource person, Shri E.V. Chandru, Advocate Chennai, to this workshop on Capacity Building Orientation Program on New Criminal Laws 2023. I request, sir, to continue his lecture on the remaining provisions of BNSS. Sir, you had asked me to remind me about 2 provisions. That is one, the new 2 provisions, that is 223 and 356. And we have discussed in detail. I would request you to enlighten our officers on those 2 provisions, sir. Thank you so much, sir.
Thank you so much. Good morning, dear judges. Yes. Yesterday we were talking about some provisions where may has to be read as shall and shall has to be read as may, right? I told you that 154 subsection 1 of CRPC was considered by the Honorable Supreme Court as 154 subsection 1 was considered that shall is shall and violation of that should lead to punishment and contempt. Okay, this is with regard to 154 subsection 1. 154 subsection 2 of CRPC, which speaks about a copy shall be given to the informant. Okay, whether this shall is shall or may. See, I told you one thing, consequences and the social implication. Just by not giving a copy to that person is not a bigger crime. Right? In that score, you write a judgment of the Honorable Supreme Court. State represented by Inspector of Police, Chennai. State represented that 154 subsection 2 of CRPC, even though the word shall is there, it need not be taken as shall and it is only may. Okay, state represented by Inspector of Police, Chennai versus N.S. Jnaneswaran. N.S. Jnaneswaran, G-N-A-N-A E-S-W-A-R-A-N, Jnaneswaran, 2013 Supreme Court. Okay. State represented by Inspector of Police, Chennai versus Jnaneswaran. So, social implications also has to be seen. And it is all the work of constitutional courts, whether these are may, this may is shall, all this. Okay. As non-interpreters of law at the district level, words shall always be taken as mostly shall, unless said by the constitutional courts otherwise. Okay? Yes. Where did we stop in the yesterday session? Which law, which provision? Lastly? 170? 173. Okay. Coming to 174. What is 174? 174 is equivalent to section 155 of CRPC. 174 now says, any informant who goes to the police station with a case of non-cognizable offense, then police person is expected to record the non-cognizable offense. One thing, 155 previously said you record the non-cognizable offense in the register called as NC register. In Tamil Nadu, that register is called as CSR, Community Service Register. In Pondicherry, that register is called as NC register, non-cognizable register. I do not know about NC. Okay, in Tamil Nadu, it is CSR, Community Certificate Register, Community Service Register. Okay, so previously 155 says you register the non-cognizable case and direct the complainant to the, direct the informant to the court. Now one mandate was given, one additional mandate was given, and magistrates has to be very careful on that. That is, this police people, after registration of NC in the NC register, should direct that, should send it once in 15 days, in a fortnight. Why? What will be the reason? Police are capable of interpreting all cognizable offences as easiest thing. You can go and tell anything. They will put it in the NC. Now the greater wisdom, the magistrates, after perusing it, if they feel that it is fraudulently done, or it is willfully done, or ignorantly done, then they can tell the police people, direct the police people that this is in fact a cognizable complaint. You have registered it in a NC register, please register an FIR. So this is for supervision of the judiciary over and above the police people. Okay, this is another one welcome thing of 174 CRPC. 174 subsection 1 Roman 2, forward the diary report of all such cases fortnightly to the magistrate. Right? Coming to section 175. 175 is akin to section 156 of CRPC. Okay, in 175, one important provision is, it says, provided that considering the nature and gravity of the offence, the superintendent of police may require the DSP to investigate the case, all cases. Previously, DSPs are were empowered by the law only to investigate cases which are very grave. What are the cases where DSP has to? SC/ST cases, dowry harassment cases, 304B, then POCSO. Now, the welcome provision is, if the superintendent of police feels that nature and gravity warrants the station house officer not to investigate, he can entrust the investigation to DSP. It is the wisdom of the superintendent of police. This is one thing in 175 proviso, subsection 1 proviso. Then 175 subsection 3 is very important. What does it say? Any magistrate empowered under section 190, section 210, that is 190 of CRPC. Present 210 is 190 of CRPC. After considering the application supported by an affidavit, this 175.3 is 156.3, right? Previously, 156.3 was used by an failed informant to set the law into motion with the help of magistrate. Okay? Can that be called as a private complaint? Is it a private complaint? Madam, you are right. No. 156.3 is not a private complaint. An aggrieved person, on failure by the police to register FIR, he approaches the magistrate to direct the police to register an FIR. It is called as an application to the magistrate. Why I am insisting is, if it is a private complaint, then Swan's cognizance, Swan statement, everything will follow. Under 156 subsection 3, the word you should use it is an application to magistrate. Now, it is not a private complaint to the magistrate under 200. Please note that. Okay? In Supreme Court uses the word for 156.3 as application to magistrate because there is no cognizance in that. 2, there is no recording of Swan statement. Whenever 156.3 is filed, magistrate will peruse whether the application reveals a cognizable offence, whether such was given to the police, and whether you have followed the procedures mandated under 154.1 and 154.3, whether there is a AD card which you have sent to the SP. If all these are followed, previously before 2014, before Priyanka Srivatsav, no affidavit business. What has happened in Priyanka Srivatsav case? a bank officer was harassed by an accused. Why? The bank officer committed two sins. First sin is to give a loan. Second gravest sin is to ask for repayment. In India, you should never ask for repayment, right? Especially government banks, it is all our father-in-law's property. We will only take loan nicely, showing all our teeth, right? If that man comes or if they insist for repayment, then we will become very angry. Then the tool in our hand is private complaint. That the man came, he misbehaved with my wife, he came in an inappropriate time, he threatened me, all this. Priyanka Srivastava is an example for all this. Supreme Court got irked on the attitude of unscrupulous elements like the one who has caused trouble to the bank officer. That bank officer was harassed for 20 years by various private complaints by the one who has taken loan. So Supreme Court said, see what happens previously 2014, you file an application, you go to the police station, lodge an FIR. He will not lodge. You come to the court, 156(3). Mechanically it will be ordered. What? Yes, on perusal, I can see a cognizable offense, register FIR. You just think of a registration of false FIR, right? Thank God we all have no FIRs on us. One FIR will give us all sleepless nights. We know that Supreme Court has said many a time, what is FIR after all? It is only an allegation, you disprove. See, the amount of shame or shy a man feels to go to the police station, followed by investigation, and followed by dragging of proceedings in the court, and think of the defense counsel's wisdom in asking cross-examination, mostly irrelevant and hardly relevant questions, right? And where this journey begins and when it will end. So all these are for people of our mentality, no, Indians, cases against them is like dying, right? We don't have very thick skin to resist cases and all. A small notice from a court or small notice from an advocate, a summons from a court, an FIR on us, it is very shocking to a person at least of a middle class family, leave alone high-level politicians and high-level executives. For them it may be everyday affair, right? So, Priyanka Srivastava, Supreme Court said, enough, any man who comes to the court under 156(3), aggrieved on non-registration, shall file an affidavit. Because if he ventures to file an application along with an affidavit, at least the court can catch him for perjury. So the Supreme Court was kind enough, gracious enough to put a bar for all unscrupulous elements, right? What happened now? It has become, filing of affidavit has become a law. Previously, I told you yesterday itself, there are two laws in India. One is under Article 141, laws declared by the Supreme Court, right? 245, Parliament makes laws. The only difference is Supreme Court declares laws. Under Article 141, Supreme Court never makes laws. Parliament under 245, the word used is Parliament can make laws throughout the country or for any part of the country. So Parliament makes laws under 245. Supreme Court declares laws. Can Supreme Court make law? Supreme Court cannot make law, but Supreme Court can make rules under Article 142, right? Witness protection scheme, right? For before this Posh Act, sexual harassment, this thing. What is the famous case law? Vishaka versus which year? Excellent, madam. When our government made the law? Immediately 2013. Right. So sometimes, no, as an advocate or as a human being, you cannot resist scolding the person in power. I am using the word shameless it is. Supreme Court has said from 1947, till 1997, you do not have any law to protect the right of working woman. Such a sensitivity has prevailed upon the Supreme Court in 1997 because a woman was gang raped. In Vishaka's case, it was Vishaka as an NGO. Prior to that, a lady who has not committed any sin, she has only performed her job. What is her job? To prevent child marriage in Rajasthan. Only she was conscious enough to do the duty. She prevented marriage of a 1-year-old girl. Right? What barbaric attitude is this to give a child in marriage? And this divinely lady prevented that. And the price which she has to pay is gang rape and shameless acquittal. Right? Supreme Court addressed this issue and said, come up with a law in 1997. Parliament is kind enough to pass the law immediately in 2013. Right? Yes, we will come to this once again. So now 175(3) warrants filing of an affidavit along with an application to magistrate. This is one thing. Then 175(4) is a new addition. What it says? CHANDRU goes to the police station, intends to file an FIR as against a public servant. Now this episode is entirely new from what we discussed earlier, right? CHANDRU goes as a common man, right, either with a false case or a bona fide case to the police station, ventures to register an FIR as against a public servant. Police people refuses to register an FIR. What is the alternative? RPID to the SP, then that doesn't materialize, come to the magistrate. Now, I am before the magistrate under 175(3) on an information which I have ventured to give as against a public servant. For this, the magistrate should not direct the police for registering an FIR. If 175(3) application is filed as against a public servant as a proposed accused, the procedure that the magistrate should follow is, first, before issuing orders to the magistrate, you should issue a notice to the accused and hear the accused as to what has happened, why this man is coming on a on an application for registration of FIR. Along with, the magistrate will call for the proposed accused superior officer to submit a report. So from 1st July 2024, you all should read, from now itself you should read the concept of doctrine of pleasure. Article 310 of CRPC speaks of doctrine of pleasure. You know what is doctrine of pleasure? Unless and until you enjoy the pleasure of the President of India, you can hold a post. This is for bigger post. Now what is happening is, any public servant, if he becomes a proposed accused in a court of law, that public servant will be heard, either it is a complaint under 223 or it is a process under 175(3). For anything, a public servant will be heard before he becomes an accused. And more important is, accused will be heard. Superior will file report which will contain all documents plus or minus. So if a superior officer wants to fight against you, he can finish you through all this. So pray God that you should have all good superior officers. Or use the doctrine of pleasure. Beyond that, I am not going to talk. You understand, dear judges, why this is introduced in the parliament? Is it a good thing or bad thing? In fact, it is a good thing, right? Law and always law presumes people are moral. Law can never presume vice, V-I-S-E. Law will presume only moral. Law will presume that everybody is good. Law also presumes that subordinates will be Subordinates will be protected by superiors. Law always presumes, right? Yes. This is an attempt by the Parliament to prevent frivolous litigations. That's all. Okay, it is an opportunity. I told you, no, in this part of the country, we are not very thick-skinned to face all frivolous litigations. So this is a greatest protection. It has to be used very sensitively. And superior officers should always think that, see, when a conflict of interest will come before a superior and a subordinate. If both are honest, if both are conscious, if both wants to save the institution, excellent, right? If either of them wants to work out of the institution or against the institution, then the problem comes, okay? So the court will assess what is the real situation. Because he is a public servant, court presumes that this man would have worked for betterment of the state. And some scrupulous element in the name of informant is harassing him. The court is satisfied that he has discharged his duty properly as per the report submitted by the superior and as per the version of the accused. Court can drop everything at the outset. Okay? This is 175 subsection 3. This is verbatim reflected in 223 of present CRPC. Okay. Then 176, subsection 1, proviso B. In that, once again, proviso. 176, subsection 1, proviso. In that, A and B. Thereafter, a proviso. In that, audio, video, electronic means, including mobile phone. A victim of rape can be examined in her house and proceedings can be recorded in a mobile phone. Then 176 subsection 3, we have already dealt that. I have told you all judgments also yesterday. What are the judgments? Krishan Kumar Malik. Okay, Krishan Kumar Malik's case was the state of Haryana. Then Rajendra Prahalad Vasnik. Thereafter Chotkau. Thereafter Munna Pandey. Then Ravi was the state of Maharashtra. Right? Now the code, now the Sanhita wants to see that any offense which is grave in nature and punishable more than 10 years, 10 or 7 years? Yes, 7 years. It should definitely undergo a process of forensic evidence. So, okay, by today afternoon 2 o'clock I am leaving you. Whether Chandru can be detected thereafter by a forensic team here? Certainly. What will be here? Some nasty hairs, 1 or 2 grey hairs, 1 or 2 black hairs, right? It will definitely fall down. Salivas. Bangalore, no sweat. If I go to Gujarat, I can be found out by sweat by forensic team. Every one of you can be detected by a forensic team. The presence can be ascertained. Need is only a good forensic team. Okay, presence can be ascertained very well. These cloth fibers, these fabrics, these small, because I am touching like this, small threads of that will fall down. If the team is excellent, it can trace the small fabric thread of mine on the victim's body or on the victim's cloth. Read there are so many judgments in foreign countries where they are doing investigations on micro levels. This fabric thread of Chandru is on a girl, right? If what our police will do if I learn this, they will ask one of the dress of Chandru and scratch it on that and say Chandru has went to that girl. See, we always know how to do something, manipulate. Read, beautiful judgments are there, envious judgments are there. Excellent investigations are made. It's small fabric of the girl's dress will be in the car. The case will be the man kidnapped the girl and through this side he went. After some time the girl is missing. What is the evidence? The girl's fabric will be in the car or the seat where she was sitting. So investigation should be like that. It should be envious. See, any person who occupies a public position, common man, should envy that man's honesty, integrity, and the man's conscience in work. Right? Such a day we will dream. This country should have a lot of conscious people and people who work for the institution. We will dream for that. Cause the forensic expert, I am reading 176 subsection 3, third line. Cause the forensic expert to visit this crime scene to collect forensic evidence in the offense and also cause videography of the process on mobile phone or any other electronic device, provided that where forensic facility is not available in respect of any such offense, the state government shall, until the facility in respect of that matter is developed or made in the state, notify the utilization of such facility of any other state. I think in all the states forensic facilities are there. In Tamil Nadu and all, there are mobile forensic laboratories and each district has got a forensic laboratory. It is not the state. Now law says about the state. In Tamil Nadu and all, each district has got a forensic laboratory. In Pondicherry also, each taluk or something and mobile things are there. Collection of sample is important. Should definitely have. See, we are playing with the rights of the victim. I am once again telling, we are all not God, because of God, we are all happy. No, in our houses, no incidents of all this. Think of the common man. He has got greater faith and belief in the system. If investigation is very poor, right? I will also ask all of you to go through one judgment you might be perhaps knowing. State of Gujarat versus Kishanbhai. All honorable criminal court judges should have this judgment with you. State of Gujarat versus Kishanbhai, 2014 Supreme Court. I think prosecutors will be knowing this. State of Gujarat versus Kishanbhai, 2014 Supreme Court, right? Read the judgment fully. This judgment, the Supreme Court directed each of the state government to form a committee called a screening committee. What is the work of the screening committee? Screening committee should call for the judgments of acquittal from all courts. And if the honorable judge, while acquitting, writes a note that this acquittal is because of the shabby investigation or willfully faulty investigation, there are two things. Investigation out of ignorance, investigation out of feigned ignorance. What is feigned ignorance? Acting, pretending. They know better than you and me. But they will make investigation of such type that the accused goes off. Supreme Court says, duty of the trial judge is to give a finding why the investigation failed in this case. If the honorable judge writes that the investigation has failed only because of the lack of the knowledge or the arrogance of the police officer or the willful disobedience of law, then three suggestions were given by the Honorable Supreme Court that that man should not be involved in the process of investigation anymore. He should be demoted, he should be sent out. In how many states all this were implemented? Think of the greater wisdom of the Supreme Court. Supreme Court has cried much. If you read the Supreme Court judgment, you will really, tears will roll down. Those judges, they have laid down so many directions, laws, such that the country should be taken up forward. But everybody should think like that. How many judges have written in their judgments that investigation is poor, this man has to be governed under Kishanbhai direction? See, unless we do all this, we are not enemies to police. Whether that lady is scolding me, ma? Not like that. Okay. I don't understand what is. She said Wi-Fi connection left. Yes. Right? So see, unless judges who reflects the conscience of the society write something like that, if your conscience says that this man has voluntarily misbehaved in the investigation team will not come up. We are not enemies of police. We are aware and conscious that if a team like police is not there, we will not live in the peace which we are enjoying now. We are all aware of that. But think of one man crying in the home who has lost the case. I am thinking of that victim and the victim's parents. See, you just take a knife, kill somebody, you take a knife, you just dissect somebody, remove some portion of the body, you see the wife of the man, see the child of the man, see the father of the man, right? Because of that spoilt man, his whole chain, the next generation, other generations have gone already. So think of that fellow also. That is what I am impressing upon you from yesterday. Think of the victim who is crying in loneliness in the home. Right? To have a small back pain itself is very difficult for us. To have a dysentery itself is very difficult. Right? To have a small neck comfort is a big thing. People are coming with all cuts throughout their body. And we are not worried on that. We are not thinking about the dysfunction which he will enjoy throughout the life. What will be the solace for that fellow? Giving compensation. In all cases, you should definitely do two things, honorable judges. One is, you should try to see whether the case fits under Probation of Offenders Act. If you feel that that accused has done a certain crime, not with greater plan, but accidentally, you can definitely invoke Probation of Offenders Act 1958. Okay? There are two provisions. One is Section 360 and 361 in CRPC, which speaks about probation. Suppose Probation of Offenders Act 1958 has come into force in your state, it is there. So 360, 361 is mother-in-law. She should become silent. Right? This was stated by the Honorable Supreme Court in Chani versus State of UP. CHANNI, Chani versus State of UP, a judgment of Honorable Justice Arijit Pasayat. Excellent judgment. State of UP. Next judgment is 2019, Lakhan Lal alias Lakhan Singh. Lakhan Lal alias Lakhan Singh was a State of MP. 2019, Honorable Supreme Court, authored by Honorable Justice Sanjay Kishan Kaul. Lakhan Lal alias Lakhan Singh was a State of MP. In that, the Honorable Supreme Court said, courts can either invoke probation or invoke 360. That judgment is per incurium. Why? When PO Act has come into force, Section 19 of PO Act says, Section 19 of PO Act says, whenever the state is notifying me, CRPC is not applicable. Chani versus state is an authority on the subject. Subsequent judgment, Lakhan Lal has not considered Section 19 also and has also not discussed about Chani. So that judgment is per incurium. Right? Any judgment which has not relied upon a provision of law or has not discussed a previous judicial precedent, it becomes per incurium. Right? One thing is PO. Please see that an accused who has committed a crime innocently without much of mastermind can be reformed and put back. Because men should always be pardoned. Right? In that score, what you can do, if you feel that that fellow has committed an accidental crime, you ask him to compensate the victim sufficiently. Right? He can compensate. That is one thing. Another thing is, one judgment is Eliamma was a state of Karnataka. Eliamma. E-L-I-A-M-M-A. Eliamma was a state of Karnataka. It is a Supreme Court judgment, where Supreme Court said, if in a case of conviction, if the court has not discussed why this man is not entitled for probation, such judgment should be remanded back. How many judgments were remanded thereafter? See? Supreme Court says in Eliamma that if a judge is convicting a man, she or he should say why this man is not entitled for PO Act. This is one thing. Then Supreme Court says that every victim has a right to be compensated. Okay. So in all the criminal court judgments, two things are mandatory. One is probation, why entitled or why not entitled. As a matter of right, nobody can pressurize you and say you just give me probation. Right? Second is, in every judgment you should say how much of compensation the victim is entitled and how much of compensation will be paid by the accused. It is not the state should pay. When the accused do not have the economic resources, then in that circumstances, the state should pay. How we will ascertain economic resource of the accused in a criminal case? You can put questions. Court can always put questions. And court can also ask for a PO report. Because post-conviction, you have got another stage called as sentencing. Sentencing is not an empty formality. Please read Manoj versus State of MP 2021. Manoj versus State of MP 2021. Sentencing is not an empty formality, and sentencing is not that after conviction you are leaving one paragraph empty, right? Questioned about sentence, he said, show me leniency. Supreme Court says you should collect materials from either both the prosecution and the accused, and it should be like a mini trial. It is not for the purposes of once again finding whether he is guilty or not, because that phase is already over. Which phase? Guilt phase is already over. Second phase is sentencing phase. In that sentencing phase, you should analyze two things. One is aggravating circumstances, other is mitigating circumstances. I am repeating, for a conviction or acquittal, two circumstances will be appreciated. What are the circumstances? One is incriminating circumstances. For a conviction, court will appreciate incriminating circumstances. For an acquittal, court will appreciate extenuating circumstances. What is incriminating circumstances? Incriminating circumstances are those circumstances which connect the accused with the crime. Incriminating circumstances are materials or evidence. There will be abundance of materials which will connect the crime and the criminal. Extenuating circumstances are circumstances where they will disconnect the crime and the criminal. So you will come to the conclusion of, if extenuating circumstances are more, what conclusion you will come? Acquittal. Incriminating, conviction. After this, no, this is over. After this, what will happen? Sentencing comes. Sentencing is not a ritual, right? In sentencing, the accused will try to please the court, projecting mitigating circumstances. What is mitigating? Minimizing circumstances. That is, court will see what is the sentence I have to give. When the sentencing policy in that code is persuasive sentence. In sentencing also, there are two things. One is persuasive sentence, another is determinate sentence. Right? What is persuasive sentence? Persuasive sentence is like this. In 307, 326, what is the mandate of law? Court may convict the person for life. So, up to life. Court can also give a punishment of what? How many days? 1 day. See, when law says he can be convicted for an imprisonment which may extend up to life, that may extend will start from 1. 326 says the conviction may be for a tenure of 10 years or life. So it can, because 326 is basically tried by magistrate. Only the magistrate finds during sentencing that he should be given more sentence, it will be committed to the superior court. Otherwise, it is the discretion. Whenever discretion is provided in a sentence, like punishment may extend up to this, it is called as persuasive sentence. That is, post-conviction, the accused will stand, the convict will stand before the court and persuade the court for a lesser sentence. Understand, dear judges? 326 capital A. What does it say? Acid attack. It says the punishment shall not be less than this and shall be extended to this. Now it contains two things. One is determinate sentence, another is persuasive. What is determinate in POCSO? It says punishment shall not be less than 20 years. When legislature has already fixed the sentence, it is called as determinate sentence. In that, I don't have anything to speak about mitigating or aggravated sentencing. Aggravative circumstances are those circumstances which the prosecutor will impress upon the court after conviction. Prosecutor will say this is a case which is not fit to give a sentence. Okay. So one thing is, during conviction, court should see reasonable doubt, presumption of innocence. Two things. I will ask one question to all of you, right? Evidence Act is there, IPC is there, CRPC is there. None of the Act speaks of presumption of innocence, right? None of the Act says, rules, criminal rules, none of them says you presume the accused as innocent. None of them says let prosecution should prove the case beyond all reasonable doubt. Just to find out in CRPC or BNSS, type out reasonable doubt, no word will be there. In evidence, no word will be there. IPC, no word will be there. Where from we are just sticking to all these two? In any judgment of a criminal court, last para, in fine, prosecution has failed to prove the case beyond all reasonable doubt. Or in fine, prosecution has proved the case. Yes. Two things are inevitable in a criminal case. Prosecution has proved the case beyond all reasonable doubt, or prosecution has miserably failed to prove the case beyond reasonable doubt. Where from we had this? Dairy milk is still there. Madam, where is madam? Madam, you didn't receive it from me, madam, yesterday.
Sir, criminal jurisprudence.
Gee, this is not an answer expected from a judge. The answer is common sense, madam. See, the answer like judge-made laws, then what criminal jurisprudence are all too wide. I told you a few minutes ahead that there are only two things in this country. One is laws made by the parliament, another is Supreme Court, right? Now tell me. When, where? When, where? What Krishna here says? Okay, I have lesser time, I will tell you. 23/5/1935, in the case of Wilmington versus DPP, House of Lords of England. Wilmington versus DPP. WOLMINGTON, Wilmington versus DPP on 23/5/1935. In England, House of Lords reconsolidated two doctrines. It is called as reconsolidation of two doctrines. What are the two doctrines? One is presumption of innocence, another is proof beyond reasonable doubt. These two doctrines were reconsolidated by the House of Lords, and they said Commonwealth countries, wherever British is ruling, will follow these two. Unlike French people, because whatever the English does, the French does the opposite of that. In French, the system is accused should say that I have not committed and he should prove. The topsy-turvy of that is in England, prosecution should prove, because you allege something, you prove. These two concepts were reconsolidated, and House of Lords said you continue following this. After independence also, Honorable Supreme Court, Privy Council followed that. Supreme Court follows Privy Council judgments, right? Supreme Court has not overruled these two concepts till date. Along with this, read section 101 small a of explanation, illustration small a of Indian Evidence Act. 101 illustration small a of the Indian Evidence Act. What does it say? 101 says any person desirous of obtaining a judgment should prove the right or liability. 101 small a says prosecution should prove the case. Whatever allegation prosecution makes, prosecution should prove the case. But proof beyond reasonable doubt and all concepts which Wilmington and other judgments have derived. Another concept is also there, which is called as concept of residual doubt. One is reasonable doubt. This concept of reasonable doubt is applicable only for which stage? Conviction stage. concept of reasonable doubt is not applicable in sentencing stage. Sentencing stage will see who is the criminal, what is the crime, and who is the victim. Sometimes victim will be A plus victim. Accused will be armed, right? In these circumstances, court will see who is the crime, what is the crime, who is the criminal, and what the sentence he deserves. So the concept of reasonable doubt was there, then the concept of residual doubt was also there. Okay? What is the concept of residual doubt? Have you come across the concept of residual doubt? Supreme Court in Achak Debarma alias Ashok Debarma versus State of Tripura, Achak, A-C-H-A-K, Achak Debarma, D-E-B-E-R-M-A, alias Ashok Debarma versus State of Tripura. It is a judgment of 2013, right? This is you will understand what is residual doubt, right? This is a case, through this case I will explain the facts of this. This is a case where in the FIR it says around 30 accused came, they fired at us and killed around 40 people, burnt the houses of 40-50 people. This is the FIR. Investigation went into the line, right? During evidence, all the prosecution witnesses pointed out only to Ashok Debarma. He came, fired, and burnt out all the house. Because all the prosecution witnesses in unison says, and people have died, from Ashok Debarma also, all the incriminating materials and the weapons were seized. Court now feels that the prosecution has proved the case as against. Now during conviction phase, court will now come to the conclusion that prosecution is guilty, prosecution has proved the case. During sentencing, a doubt lingers in the mind of the judge. What will be the doubt? Whether one man, whether he is Rajinikanth or Chiranjeevi, right? And not Amitabh Bachchan also. Our heroes can do better than this, right? Court now, lingering doubt in the minds of the court, prosecution has proved the case whether one man is capable of committing murder of 40% and burning 40-50 houses, especially when investigation and 161 states otherwise. Because originally they said 30 to 40 people. This lingering doubt, in spite of the fact that court has concluded him as a convict, lingering doubt as a residue, this doubt was lingering in the minds of the judge. This doubt is called as residual doubt, and this residual doubt was given, this benefit of residual doubt was given not in the conviction phase, in the sentencing phase by the Supreme Court. However, at the later point of time, this is in 2018 or 19, however, in 2020 and 22, Supreme Court said this concept of residual doubt is not applicable in India. Okay. So why I am telling you is, you should not be misled by somebody that this residual doubt should be given importance in this thing. I will give you the judgment after tea break. I have forgotten that. I think it is Viran Nyanlal's case, but I will confirm and then tell you in which case the Supreme Court said it is not applicable. Okay. That judgment was delivered by Her Lordship Justice Indira Banerjee, that even foreign countries are very slow in using residual doubt concept, but however you should be aware of that. Okay. Yes. Okay, after forensic, 179 is equivalent to 160. 179 subsection 1, proviso, third line. Previously, who are exempted? Woman, a man of 60 years and a child of 14 years. Police should not call for recording statements. Now, 179 subsection 1 proviso, third line says, it also added acute illness. A man with acute illness also need not be summoned to the police station. But I have told you, tail contains the sting always. See the subsequent proviso clause. Provided further that if such person is willing to attend the police station, such person may be permitted to do so. This is doing justice to victims or injustice? Now what our police will do? In all GD they will write this first. Even though she is a woman, she was dare enough to come to my police station. Even though he is a child, he came to the police station. So this is called as tale containing the sting. First main section, it is appearing as if woman, child and small children, acute illness people are protected. Policeman can write like that also. See, whenever I refer to the word policeman, we are not talking about good policemen. We are talking only about exceptional policemen. Then 180, examination of witness by police. In that subsection 3, then proviso. What does it say? Statement may also be recorded by audio video means. May also be recorded by audio video means. Okay. Judges, I want to ask you one question. Whether a charge sheet should definitely contain 161 statements, or a charge sheet can reach you without a 161 statement with list of witness, 100 list of witnesses, no statements. Policeman gives a CD with that saying that I called them under 160, I examined them, they are all aware of the fact, they will come and depose everything in the court. So I have not recorded any statement, I am not sending anything. Can it be like this? No. Read CR versus Tuesday. CR versus Tuesday. C for Chandru, R for Radhika versus Tuesday. Okay? Don't imagine anything else. CR versus Tuesday. It is a judgment of Kerala High Court. This judgment contains all the Supreme Court judgments. That is the reason I am not telling all those. This judgment, relying upon Honorable Supreme Court judgment, says a policeman is not duty bound to record 161.1. Why is he may record in 160 and 161 read together, policeman may record a 161, and if he records, he shall send to the court. That is, recording of 161 is not mandatory. If he records it, it is mandatory for him to send to you. So, in serious cases of CBI, ED, NIA, what police these days, what they do, they don't record 161. Because a defense lawyer, on seeing 161 only, he starts his job of making hostile. When I use the word defense lawyer, it is not all defense lawyers. It is some defense lawyers, right? So please don't think that 161 should definitely accompany. Supreme Court judgments are otherwise. Okay? Yes. Other materials. And this man has cited so many witnesses. These witnesses, this man will also say that these witnesses are aware of the contents in the, will speak about this thing, right? Statements will not be there. But prosecution, investigating officer will say, this man will speak about this man will speak about this, but the entire statement will not come. So non-supply of statements along with charge sheet cannot make you to reject this charge sheet, because it is settled that 161 is not mandatory. It is an obligation on the police officer. You either record or not record. For this, the answer by the Supreme Court is, judge is excellent. For this, the answer by the Supreme Court in so many cases is, you expect the poor prosecution, prosecutors, you are all sitting there, no? Yes. You expect the poor investigation and prosecution to do their duty intact. Point one. Second is, investigation and prosecution are two separate agencies. You accept that? Yesterday we were talking about some signature approval and all. Supreme Court in Sarala versus Velu. Please read that judgment, have that judgment with you. Sarala versus Velu. 2001 judgment by Honorable Justice K.T. Thomas. Excellent judgment where he has deprecated the practice of police obtaining approval from prosecution. Supreme Court says, what is the prosecution business? Investigation is separate. After finishing of investigation, they should put the charge sheet with the court. When the duty of the prosecution starts? during at least framing of charges. 2 here on the charge, right? Supreme Court said pre-process of prosecution is the investigation. Both never meet together. So Sarala versus Velu says all this approval business are nonsense. Right? Now, our judge has asked one question. We all expect investigation should give all loads of paper. What the prosecution witnesses are going to say, right? I will also accept with them. Now investigation has recorded 161, prosecution conducts the case, 313 finishes. After that, beautifully accused will come and say, I have to examine 50 witnesses. Will the court is asking, or is the court asking the defense witness for 161 statement or any other pre-statement? Court itself is summoning somebody. Is court insisting for any statements? So Supreme Court said, all these are just nothing. When defense can call so many persons and no statements, prior statements are given to anybody, it is all permissible under 160 and 161. Okay? Yes. Honorable judges, from yesterday, I am using the word, you will see the video audio of everything, search, seizure, identification parade, statements, and also confession, right? As human beings, will we get perplexed that I am seeing this man confessing, I am seeing this man doing search and seizure, I am seeing statements of witnesses, they all through audio video means I am seeing in black and white and in colors also that they are saying everything. Will this audio video means add to the evidentiary value or add much to admissibility or relevancy? Add to, well, whether this audio video mode of presenting paper, presenting materials to you instead of paper, see, I will tell you like that. Police files 10 pages of confession leading to discovery. What you will do? You will not even bother to read all because it is all not admissible. You take a green pen and put 4 lines and check whether pen is writing or not, and on the side you will write it as exhibit something. This becomes the admissible portion. Now, when law permits that confessions can be recorded by electronic means, 27 confessions will also be recorded in that. So, either you should adapt the trick of reading it from from the bottom you should play the video because that is the admissible portion. See, confessions will go to 3 to 4 hours. If this 10, and one good thing for accused, no. Tell me what is the good thing for accused? If he has to confess for 1 hour, tutoring has to be done for 10 hours at least. Judge, I am not joking. A man cannot talk for 1 hour like that. Confession, you will see monotonous confession. My grandfather is him, my great-grandfather is this, I am this, people who are born around me is this. You cannot tutor so many people like that, and people cannot articulate things like that. And so many funds we will have after 1st July 2024, right? It is very difficult for the police people will take the assignment of directors of cinema. They should teach that fellow to say something, right? My question is whether these confessions recorded by audio video electronic means will improve the admissibility of that. I used the word from yesterday I was telling you as gods in human form. Now I said that the human element inside will now think, I am seeing that this fellow is confessing. He is going there and taking out something. Previously, what was in paper will be given to you as a film, a short film. My question is, by seeing this, can you say, write a judgment that, no, I saw him confessing, I saw him going there and taking. Now, no evidentiary value is enhanced. The Evidence Act remains the same. but for the Form 95, but for 161 statement, but for 27 on paper, now it is all digitalized. That's all. Read one judgment of the Honorable Supreme Court in Muni Krishna alias Krishna, Muni Krishna alias Krishna versus State represented by Inspector of Police, Ulsur or Alsur, ULSOR, Alsur Police Station, Karnataka. Supreme Court judgment, 2023, sorry, 39/2022. Muni Krishna alias Krishna versus State represented by Inspector of Police, Alsur Police Station, Karnataka. 39/2022 Supreme Court. Fortunately, this was a beautiful case where the session judge, without knowing that laws will come like that, in this, a confession was recorded by an electronic video, right? Audio video means. Session judge, forgetting for a moment section 27, he said, hey, I am seeing him that he is confessing everything in audio video, and he believed the entire confession. Supreme Court said, whether a confession is recorded by video or not, Evidence Act remains the same. Now also Evidence Act remains the same. So please don't get carried away by police showing you all pictures. 161 will be a picture, search and seizure will be a picture, then identification period will be in picture. Everything is cinematic now. But Evidence Act remains. So admissibility and relevancy, it is the same thing. Please read Muni Krishna. One judge has contributed for that. Whether that judge is here? Because it is Ulsur. Alsur. Yes. Alsur at Bengaluru. Judge? No, even if he is here, it is a contribution. Right? There are two types of contribution, positive and negative. He has done a greater good for the entire country. Right? See, we will also tend to believe the audio video. No, see, one shortcoming of a human being is anything comes in a paper we still believe anything comes in a paper is true. Anything shown in TV is true. Even judges believes that. Overall, greater people of wisdom. That is called as media trial. Bound to commit mistake. See, I will think like this. This case, no, Nirbhaya's case in Delhi, it received lot of media attention. Imagine the same crime in a remotest village in Karnataka and has not at all had any media attention. It would have ended in an acquittal. Why I am using the word it would have ended in an acquittal means, in this case, you should read Mukesh versus NCT. That is Nirbhaya's case. Please take the judgment, read that 2017, Mukesh versus NCT Delhi, 2017 Supreme Court. In this case, Supreme Court has appointed, I think it is Hegde, Santosh Hegde. Mukesh versus NCT Delhi, 2017 Supreme Court, bracket Nirbhaya's case. All prosecutions favoring cases will be there. If judges wants case law supporting prosecution, you just type out Mukesh versus State, on any heading you will find. Right? That is one bonus for you. Secondly, Supreme Court has appointed one amicus curiae for aiding the court. I think it is Santosh Hegde. You know what he said? This case is a fit case for acquittal. It is not the defense lawyer's argument. Argument of? He said it is all false and frivolous prosecution. This is the quality of an amicus curiae. Because amicus curiae is one who should help the court, who should aid the court in rendering justice. That man, you read the judgment, he said, no, this is a case in which the Supreme Court should acquit. Because I suspect so many things in the investigation and prosecution. See, this girl, we have all mercy for that girl. This girl, investigation says, she dying declaration, 1, 2, 3, fourth dying declaration. Usually, you will suspect the second dying declaration, usually. This girl's fourth dying declaration was believed. In the fourth dying declaration, she is telling that when I was raped and molested, they were calling them by names. And these are the names. Such names were not revealed in the previous 3 dying declarations. Supreme Court now says she came in a very comatic stage. She was in the verge of death and her health was deteriorating. After few days, she would have regained the health and there is all possibilities of she revealing. Yes. See, in every case, in every case, many a times, truth will appear more fictional. In many a case, I am repeating, truth will appear more fictional than false. Because false can be always put into proper order. Truth cannot be put like that. Truth is random. So there are this amicus curiae like this, he has pointed out so many points and said this is a fit case for acquittal. Had this not received media attention, it would have gone to dogs. Okay? Yes. So media is very powerful to influence everybody. Don't say judges alone. So Muni Krishna is very important, right? Then recording of confession and statements. 183, there is no much change. But for subsection 6 proviso, subsection 6 proviso. What it is, it speaks of, you are all aware of one judgment from Karnataka, no? State of Karnataka by Nona Vinakere versus Shivanna alias Tarkare Shivanna. Excellent. You are all very knowledgeable, educated people. Academy should not have arranged a class for you. Okay, State of Karnataka versus, by Nona Vinakere versus Shivanna alias Tarkare Shivanna, 2014 Supreme Court. Okay, a beautiful judgment with a lot of sensitivity. Point 1. Yes, Shivanna alias Tarkare Shivanna. Pronunciation is right? Yes. Amma? Nona Vinakere. Yes. One difficulty is I am going to various states. Every state is teaching me some pronunciation. I will definitely forget it in the stage itself. And the funniest part is you go to NJA, two judges from all the states and union territories. You say some judgment, everybody will try to correct. And funniest thing is, I was referring to Salem Bar Association yesterday, no? I took a session in Bhopal, Madhya Pradesh. And in all North Indian states, but for Karnataka, even I think in Telangana they corrected me. When I said Salem Advocates Bar Association case, it is Salem. Everybody corrected everywhere. Chandru sir, it is not Salem. I said, Hare, this is my state's village man, I know that better. It is called as Salem. So the fun is everywhere you are corrected for pronunciation. And as such there is, in Tamil Nadu, you take Tamil Nadu, for every 70 kilometers, the way Tamil is pronounced is funny. Here also, sir. I have some Madras and Pondicherry Tamil. If I go to Coimbatore or Kanyakumari, they will tease me. We talk Tamil like stopping and talking, right? They will say, Enangana, Oninglanganan. They will just do like that. So Tamil also for every 70 kilometers it changes. That is Karnataka ji? Every 30 kilometers. My God. Every 15. My senior, Mrs. Vrinda Mohan, she is a Malayali. Right? She was born and brought up in. Sir, I ate Malayali food for 20 years, sir. I was getting all blessings and scoldings from my senior for 20 years. Right? So Malayalam will be there. It is in my blood also. I said, no, my brother's blood is Karnataka soil. My blood is Keralite soil. So my family represents national integrity. We should be an example to people who fought on silly games, no, linguistics and other things. I told in my academy, you know, there is no gap between my this thing and this thing. That is my good enemy. I told my academy people some 3 months back, you see, we should become more matured. Right? I told in the academy. I thought then thereafter I should not use all this. I said, I am going everywhere. People are inviting me. They love me so much. They don't think of any linguistics and other barriers. See, you go to Tripura, you go to Leh Ladakh, people are very good in this country. This country is an excellent country. And but for some small miscreants doing all these tricks for vote banks, otherwise these people are very good. You cannot find such godly people like Indians. They love you irrespective of all caste, creed, religion, everything. Right? That is the proud of the country. And that is the reason this country stands for these many centuries. And it will also keep standing. Right? You should see the Leh Ladakh people. Just very good people, very divinely people, very loving people. They don't discriminate. People don't discriminate. But for this vote banks politics, we don't know how to fight, and we are people with good tolerance and flexibility. Right? Everywhere in Tamil Nadu, each day, if you don't send that Bellary onions, we will die. See, Tamil Nadu, and whenever there is a rain in Karnataka, tomatoes will be 200 rupees there. If Karnataka do not have rain, and Karnataka do not have rain and flood, we will have tomatoes for 20 rupees, 15 rupees. We should first think that this is one country, one unit, and that should be promoted by people. Okay. This Sivanna case, Honorable Supreme Court says that any person who is inflicted by a sexual assault, if she is temporarily or permanently, physically or mentally affected, she need not be harassed by recording of 161 statement by the police. And I will tell you like this. From yesterday I am talking about something called a sensitivity. Right? Especially girl children. See, look at the smile and the shyness of a girl child. Right? Even with her mother she is shy. Right? You see, that is the pride of the girl child. You go to any house, what the girl child will do? She will just go and hug the mother, and she will just see you from this and that side, right? Such a child was ravished by a fool of a lesser degree, right? Because of bad parentage and the bad society also, right? You cannot put the whole blame on that fellow. He does something. You expect the child to say all these unsavory stories once to policeman, once to magistrate, then in a chief examination. Supreme Court in Nona Vinakari says, what is the fun of recording 161? Anyhow it will be thrown. If at all an affair is filed with regarding to cases like this, take the child immediately to a woman magistrate preferably. Because I will tell you without any shame, I have told this many a times, 4 or 5 years back or 3 years back, I had some small piles problem. I am now 50. 3-4 years back, I will be 46, 47. Right? I think 46, 47 is an old man. You should always think old with your age. I thought of going to a hospital. I went to a hospital because the pain is too much. I went there. I thought a doctor will be in one room. Doctor was sitting in a bigger hall. 2 or 3 nurses are there and other male nurses are also there. I went and sat. I told him, doctor, I have got a pile. He said, yes, you come to the stretcher and remove the pant. A man of 47, 46 doesn't want to remove the pant to get cured. Cell phone is cell phone is my savior then. I pretended as if I have got a call, left the hospital. See, this is the inherent shyness of every human being, right? Think of a girl, a woman raped by some fool. You want that child to be shameless. Doctor wants to examine. Doctor wants to remove the pant of the child. This policeman after registration also, he wants to hear all the story. Magistrate 161, he wants to hear this. Chief examination, you want to see, will that not shake the child's soul? Are we not co-human beings to feel all this sensitivity? can the child say this? How painful is that for the child? Supreme Court in 2014 itself said, please don't harass the child by a 161 statement. Bring the child for 164, and if you feel that the child is mentally, physically, temporarily or permanently disabled, will not any child temporarily get disabled on this, at least? So Supreme Court said, use that 164 statement recorded by the magistrate as chief. So the child will reveal this only once. With great pain, with a magistrate, she will reveal only once. I mean the word child also includes the woman. Right? So please take very sensitively all this. I have told you, you are the gods for the people in Karnataka. Right? They should feel that even though I was victimized by a man, system has taken nice care of me. I am not, see, please read that judgment, Mallikarjuna Kodagali versus State of Karnataka. State of Mallikarjuna Kodagali, it is Mallikarjuna Kodagali or Malli? Yes, I am right then. Mallikarjuna Kodagali versus State of Karnataka, 2018 Supreme Court. Okay, versus State of Karnataka, 2018 full bench. It speaks about victimology. It says, Mallikarjuna Kodagali versus State of Karnataka, 2018 Supreme Court full bench. Please read the judgment thoroughly. It says about two victimization. One is primary victimization, that the crime on her is the primary victimization. Secondary victimization is by the police, by the court, and by the lawyers. That is, if a person becomes a victim, system is making her a victim once again. Supreme Court said that crime on her is the first primary victimization. She feels that I am victimized by the criminal. See, suppose a girl is raped, no, she feels that she is victimized. Secondly, she also feels that police has harassed me enough, doctor has harassed me enough, judges have harassed me enough, defense lawyer has harassed me enough. These are all secondary victimizations, and court says we should be sensitive enough that she should not be victimized, and after the crime has been committed on her, she should be rehabilitized. Right? Good morning, sir. Thank you, sir. So, Mallikarjuna Kodagali versus State of Karnataka speaks of primary victimization and secondary victimization. Shivanna intends that she should not be victimized for the second time by recording multiple times her statements. And doctors also, whenever many POCSO cases, you ask the children, they go to the doctors. Where they are admitted in a woman ward. Along with the child, so many elderly women are present, and this child is not given a preferential treatment of examination and sent to home immediately. As a child, what it will do, after the pain is subsided, it keeps moving around and playing around. Every woman will call her and ask, why is that you are here? See, this is also putting the child into shame. All this has to be attended with a very sensitive heart. Will we allow our children to be like that? What we will do? We will just have the children like this. We will feel as if we are raped. Right? These sensitivities has to be imparted only by you, whom we believe that you are all gods in human form. Right? But for you people, nobody will be sensitive. For a doctor, it is a work. For a policeman, it is a case. For a judge, it is neither a work nor a case. For a judge, it is deliverance of justice. Right? Yesterday evening, now sir is there, I can say this. Yesterday evening, after the session is over, I was in the veranda for some time. Some judges were asking my phone number and taking some photos with me. Right? One additional director, assistant director told me that A.V. Chandrasekharan sir is waiting for you. I asked him who he is. He said he is Lordship. He came to the session. I said nobody told me. You have not told me. I am sorry for that. I just went there. He gave me the greatest payment in my life yesterday. No, what is it? No, he said, Chandru, I just came. Your session was on my ears. I told immediately to the staff, a good person, subject knowing person is taking a session, right? Where I am, where he is. I am a small dust in front of them, right? They are all law givers. I just reproduce what they have said. Comparing to them, no, I repeat that I am a small insignificant dust. This great man told me twice that I told everybody that it is a good session. And along with that, he blessed me. Thereafter, he said, you keep coming to the academy. Then also he called the librarian or somebody and said, you present a book in my cost to Chandru, Evidence Act book. Right? Sir added to that and sir said, Chandru, I missed your session. I will come to your session today. But my son, who was listening you in live, said a good man is doing some good job. This is the payment I received from Karnataka people yesterday. Right? I am here for 2 days. 2 days are working days. I missed the court, thinking that I should not. I think it as a national service. Yesterday, 2 cases which are very important, my juniors could not get orders in that. It was worrying me, but it was worrying me. See, any advocate wants to get an order. No, clients have believed me and they have paid me for that. But these 2 payments by 2 godly people yesterday, I slept nicely as usual. Right? I bow down once again to my lords and to you also for treating me with all love and goodness. Right? I felt extremely happy. What else you want? Having greetings and wishes from a great judge. See, he could have just ignored me. Or he could have sat for 5-10 minutes here and walked off thinking that one man from Tamil Nadu is coming on small boy, is taking classes, that's all. He was waiting, such magnanimity, no? It is the reason Karnataka is still cool and it is raining also. Okay? I told my mother yesterday evening, I didn't use fan, I didn't use AC, but still I am not sweating. She said, how is it on May month? I said, there are many good people here, that is the reason it is like that. I told my mother, honestly, see, there is no fan, I am not using, there is a fan, but I didn't use it, I don't feel like using it. Right? Previously, we have also seen search and seizure by audio-video bins. Now it is 185 subsection 2 proviso. What 185 subsection 2 proviso? What they have added? Audio-video electronic means through mobile phone. Then 185 subsection 5. Now time frame. Copies of the same should be sent to the court. So everything, all stakeholders, some time limit is prescribed. At least see, we will see like this. We are going on the road. National Highway, Express Avenue. National Highway, they have put 80 kilometers per hour. Express Avenue, 100 kilometers is minimum speed. Right? They have prescribed certain speed. Like that, CRPC is prescribing certain time limits. To follow that or not, first thing is our conscience and sensitivity. If stakeholders are sensitive enough to follow that, they will follow. Or we are always having a supervisory jurisdiction for every stakeholder. If you take the stick, then, see, if they are not sensitive, then stick has to make them sensitive. Because parliamentarians are representatives of people. Let any party rule the parliament. That is not our thing. Whatever it is the will of the majority of the people. They are making certain laws. Making laws are not for making play. Right? It is for a very serious business. What parliament thinks? Because of lack of time frame only, so many cases are pending. So they are devising something which has to be implemented. Right? Then coming to 187. One doubt, first I will finish one thing. In 187, subsection 5 proviso. 187 subsection 5 proviso. What proviso says? Explanation to last proviso. Provided further that no person shall be detained otherwise than in police station, under police custody, or in prison under judicial custody, or a place declared as prison by the central government or state government. This is 187 subsection 5 after explanation 2 proviso 2. Got it? It says any person in India will enjoy only two custody. One is police custody, another is judicial custody in a place which shall be termed as prison or jail. Why this came? In Gautam Naulaka versus NIA. Write this judgment. Gautam Naulaka versus NIA. It was penned by Honorable Justice K.M. Joseph. 2020 judgment. Gautam Naulaka versus NIA. The Honorable Supreme Court has given an instruction throughout the country that under section 167, house arrest is also permissible. Now the Parliament has undone that judgment. That means you cannot retain or detain any person in a house custody unless and until his house is declared as a prison. No man will want his house to be declared as a prison. So he will say, I will come to jail. Right? This is one good law to prevent disparity. Because VVIP should not be kept in their house. Gautam Naulaka versus NIA 2020 Supreme Court. It says all the magistrates and all the judges down the country can invoke section 167 for house arrest. Supreme Court, the legislature has now said, no business, he should either be in police custody or judicial custody. Now coming to 187. 187 is pari materia with section 167. Pari materia means not totally fully. It is almost pari materia. 187 was almost pari materia, was 167. Right? What is 167? 167 contains two components. Point 1, it speaks of the potency of the judge to remand a person. I am repeating, it speaks of the potency limit. I am using the word the potency limit of the judge to remand a person for a period of 60 days if charge sheet has to be filed within 90 days for offences which are punishable for 10 years and above. Please read Rakesh Kumar Paul versus State of Assam 2017 to understand what is the 10 year. 10 year means minimum 10 years prescription. Rakesh Kumar Paul versus State of Assam 2017, Honorable Justice Madan B. Lokur, full bench. Rakesh Kumar Paul versus State of Assam 2017. Right? Rakesh Kumar Paul versus State of Assam. Right? If a charge sheet has to be filed within 60 days for offences which are punishable 10 years below, 10 years and above, it is 90 days. Okay? A magistrate or a court will become impotent after that 68th day for remanding that person under 167. Because law says you can remand him only for 60 days. That impotency should be spoken of or should be told to the accused that you are entitled for, because of, what is the default? Whose default? He has defaulted in filing the charge sheet as mandated under 167. This is called a default bail. That default entails this man for a bail. Otherwise, it is called as statutory bail, mandatory bail, default bail. It is called by three names: statutory bail, mandatory bail, default bail. On default of the police, this fellow is entitled for a bail. This bail should not be conceived in no wild dream that it is a bail on merits. I am repeating, this is not a bail on merits. Irrespective of what offense he has committed, what is the merits of that, even if a bail was dismissed on merit by a superior court, this fellow, an indefeasible right will accrue upon him on the expiry of the 60th or 90th day, on the expiry of the 60th or 90th day. This is one thing. This is the main ambit and scope of section 167. You read one judgment, Kasi versus State, full bench Supreme Court, 2020. Kasi versus State, KASI versus State of Tamil Nadu. Full bench judgment. Also read one Setu versus State of Madras High Court, Setu, ACTTU. I will tell you what is Setu's judgment, what is Kasi's judgment. During COVID, Supreme Setu versus State of Tamil Nadu, Madras High Court, Madurai bench, 2019 judgment, 2020 judgment. What has happened? Supreme Court has passed an order lifting the period of limitation or raising the period of limitation for certain time. My state police, they believed that charge sheet can be filed after COVID disappears. I told you we will fight for rights. No, any right we will not miss. If a new CRPC, CPC comes, now our Chief Minister in Tamil Nadu has written a letter not to implement. Yes, we will uphold rights at any extent. Right? Like that, my state police thought charge sheet should not be filed because Supreme Court has given exemption for under the law of limitation. After 3-4 years, they can file the charge sheet. What will happen to the accused? He will be in jail. Right? This was decided by the Honorable Madras High Court, Honorable Justice G.R. Swaminathan in Setu versus State, an excellent judgment which will show to the world how a humanist judge he is and what sort of sensitivity he has displayed. He said 167 has a direct connection with Article 21 and 22. No court, including the Supreme Court, can say that a magistrate or a court can remand that person endlessly. So he said, and 167 is not a law on limitation also. Because after 60 days, IO will not come with an application and say, sir, I am filing the charge sheet after 60 days. You expand it under the limitation law. All this excellent wisdom was displayed by Honorable Justice G.R. Swaminathan and said, he also teased the police that you like a small child should not go and hide in the pallu of the mother, stating that I will hide with the judgment of the Supreme Court. This judgment was negatived by another learned judge in Kasi versus State in Tamil Nadu. Kasi versus State, another learned judge said, no, this judgment is wrong. Limitation, if it is raised, it applies for even 167. This Kasi versus State went to the Supreme Court because a man was deprived of his right to life and personal liberty. Supreme Court said the judgment of Justice G.R. Swaminathan in Setu versus State is correct judgment. Okay. So this is with regard to 167. Coming to another greater question. What is the greater question? Whether a man can be sent to police custody for an indefinite period. No. For 15 days. Then there was a great debate. What is the 15 days? When it will commence? Whether from the date of arrest or date of remand. What? When it will commence? Remand. It commences from the date of remand. Right? Judgment is Enforcement Directorate, Government of India versus Kapil Vadhavan. Kapil Vadhavan. Enforcement Directorate versus Enforcement Directorate, Government of India. EDGOI versus Kapil Vadhavan. 2023 judgment. Supreme Court. It once again reiterated the old principle that date that has to be calculated is from the date of remand. That first 15 days means first day also has to be calculated, 15th day also has to be included. So it is inclusive of the first day and the 15th day. This was the judgment which has settled all the other differing opinions by this. Now, Chagantis, I should pronounce it as Chagandi Satyanarayana. I was taught a day before yesterday in Telangana. I was pronouncing it as Chaganti because THI. But Telangana people told me that I should pronounce it as Chagandi Satyanarayana. So, Chaganti Satyanarayana was a state of AP, 1986. Chaganti Satyanarayana versus state of AP, 1986 Supreme Court. Followed by CBI versus Anupam Kulkarni, 1992. CBI versus Anupam Kulkarni, 1992. Then, in the same year, Kosanapu Ram Reddy versus State of AP, 1992 Supreme Court. All these are Supreme Court judgments. First is Chaganti Satyanarayana versus State of AP, CBI versus Anupam Kulkarni, then followed by Kosanapu Ram Reddy versus State of AP, 1992. These three judgments were affirmed and confirmed, especially CBI Anupam Kulkarni was confirmed by a 3-judges bench in Budh Singh versus State of Punjab, BUDH Singh versus State of Punjab. It is a judgment of 2000. Right? We have written all the 4 judgments. All these 4 judgments ununivocally says that police remand cannot be given beyond a period of first 15 days in that offence, for that offence, right? Even if that offence leads to a greater offence, you cannot do. But this law is not applicable if that fellow has an involvement in an altogether different offence. Okay? You understand, dear judges? See, suppose Chandru is getting arrested for 326. It gets altered into 304 or 302. If one police remand is given for first 15 days, that is over. Okay? Now, Pradeep Ram versus State of Jharkhand, I think it is 2017 or 18, Supreme Court. Pradeep Ram versus State of Jharkhand, in this context I will finish that also. Pradeep Ram versus State of Jharkhand says, Chandru is involved in an offence of 324. Right? My wife goes and gives a complaint that this fellow, this fool had given me a slap. She was admitted in a hospital. I go to the court and get a bail for 324 read with 498A. Finished. Because she is telling I have harassed, slapped. Doctors predict, doctors investigate and they found out that there is a clot in the brain because of the slap. Right? After 2 or 3 days, Chandru's wife Chandrika died. These are all imaginary. Don't go and say that he spoke something about Rexona and Chandrika. Right? Then Chandrika died. Now the case will be altered from 324 498A to 302. 302, it is a clear case of 302, or if it should be more grave, it should be filed under 304B. Because 304B is more dangerous than 302. Why? Reverse burden will be there on me. 106 of Evidence Act will stare at me. Right? Now, this Chandru has obtained a bail under 324 read with 498A. After altering this, can the police come and arrest Chandru? No. Pradeep Ram versus State of Jharkhand, please listen. Pradeep Ram versus State of Jharkhand says, if a person obtains a bail for a lesser offence and during the course of investigation, it was altered as a graver offence, it is the duty of the police to approach the judge who has granted the bail for cancellation of bail. Okay, now I will tell you what is rejection and what is cancellation, what is grant. There are 3 things in bail. One is grant of bail, rejection of bail, cancellation of bail. Chandru moves an application for 324 and 498. Now the judge can say no, this fellow has behaved like a rascal, I will not give bail, I am rejecting the bail application. This is on the own merits, judge has dismissed my bail application, he has rejected. Cancellation is a bail that was granted will be revisited, especially if there is a violation under 437(5), 439(2). Over and above 437(5), over and above 439(2), if the court in my case has also prescribed some other conditions, I violate that also will become a ground for the court to cancel. So cancellation is a very serious thing. Courts will be very slow because already a judicial mind has been applied and that mind has said this is a fellow who is entitled for bail. Now law says to check the investigating agency, to have a check on the investigating agency, because what they will do, whenever any man obtains a bail, they have got the nake of, they will have the nake of altering it into bigger offense. Now law says two things. One is police should apply for cancellation of bail of CHANDRU, stating that an altered offense was made during investigation, and if the court cancels, they can come and arrest me. Or in the alternative, if I go to the court out of anxiety, either on an anticipatory bail, I can only move an anticipatory bail because I am already in bail. If CHANDRU moves for an anticipatory bail for 302 or 304B, if that is getting cancelled, now the police will have a right to come and arrest me. This was the law laid down in Pradeep Ram versus State of Jharkhand. Please read that judgment. In Pradeep Ram versus State of Jharkhand, another thing the court has dealt upon is two things. One is there can only be two custodies. One is under 167, another is under 309. After a charge sheet is filed, there cannot be any remand under 167. This is also one distinction that was made. Even wrongly, if you write it as a remand under 167 after charge sheet, Supreme Court says it is a remand only after charge sheet, it can only be under 309. 309 do not have any time frame. 60 days, 90 days and all. 167 has got a time frame. Okay. Now, having seen this, another question, incidental question is whether grant of bail, next question, please note down very seriously, whether grant of bail will stand in the way of giving police custody. Suppose CHANDRU is an influential fellow. He goes to the Supreme Court or the High Court, obtains an anticipatory bail for 304B for killing wife. Sincere investigating agency feels that this fellow should be arrested and he should be investigated. There may be some clue for him to give a 27 evidence and some discovery. I have obtained a bail from Madras High Court for killing my wife, anticipatory bail. Now whether the police to seek police custody of me should approach Madras High Court or the jurisdictional court. Whether the jurisdictional court will dare enough to give a police custody in a case where anticipatory bail was granted by the High Court. But relying upon Dioman Upadhyay versus State of UP, relying on this judgment, Honorable Supreme Court in Sushila Agarwal versus NCT Delhi, 2020 Supreme Court, Constitutional Bench, 5 judges, Supreme Court relying upon Dioman Upadhyay versus State of UP in Sushila Agarwal, because Sushila Agarwal settled finally all the controversies with regarding to anticipatory bail. Whether time bound, whether anticipatory bail is an inferior bail. Anticipatory bail is not an inferior bail. It is the same process which you move the court under 437 or 439, right? It is the discretion of the court to give it within time frame or not. And it was once believed that a person moving an anticipatory bail, after charge sheet, he should once again go and take bail. All these doubts were dispelled and court said nothing doing. It is also a regular bail. In this, an incidental question was raised whether police should seek for cancellation of bail for taking police custody. See, cancellation is something which is a direct result of violation. Otherwise, there should be a perfect balance between the duty of investigating agency and the right of accused. Court thought that this man is eligible for bail. Court has granted bail. Now investigating agency is asking for police custody. They have also substantiated with reasonable reasons. Now court should grant police custody irrespective of the fact that bail is not getting cancelled. They are giving him to a police custody. These aspects were discussed in detail by the Honorable Supreme Court in Sushila Agarwal Constitutional Bench case. Please see that also. Now coming to 167, which is present 187. One question which was ringing in the minds of the entire country is, police custody can be given only for the first 15 days. However, 187 is telling something over and above that. This was the doubt which everybody is entertaining and doubting, right? To dispel that doubt, I will refer two judgments, because Budh Singh said, what Budh Singh said? What Budh Singh, State of Punjab 2000 said? First 15 days, it has stamped approval for CBI versus Anupam Kulkarni. So that is the law of the land, reading with 167. Now, these high-level criminals, no? Whenever a policeman goes for arresting a high-level, highly placed criminal, he will get one disease. Yes. Because he is giving chest pain to others, sometimes it is God's wish that he should also undergo some chest pain or act as chest pain, right? So, what happened whenever, sir, I should stop it. 11:30, yes, because somebody is looking at the clock. As a teacher, no, you can see only wrong things. We will be writing 100 pages rightly. 1 or 2 lines is wrong, teacher will round that. Right? Like that, Chandru's eyes is going there, because you are all seeing that. Right? Where did I stop? Budh Singh. No. We have traveled and said some chest pain. Sir is right. You are watching the class attentively, Ji. I thank you. I love you. Right. What has happened is, down the ages, because CBI versus Anupam Kulkarni has said, police remand shall not be given beyond a period of first 15 days. See, we will, whenever a surgeon's knife is made, even a cobbler will use it and a murderer will also use it. Like that, no, our murderers, they thought that somehow I will whisk off this first 15 period. And I will take refuge not in government hospital, because government hospital doctors will say, no, Chandru is acting. Other private hospitals will say, this man doesn't have an heart at all. He should be admitted forever. Right? All these blessings of private hospitals, these people were enjoying. Finally, what has happened? In 2023, a death knell was put for this in 2 judgments. One is CBI versus Vikas Mishra. CBI versus Vikas Mishra and V. Senthil Balaji versus state represented by DDED, state represented by Deputy Director Enforcement Directorate. This was also in 2023, August 2023. These Vikas Mishra's case we will first discuss. What happened? This Vikas Mishra was given in police custody for the first 1 week. Some lawyer like me would have taught him that you should immediately go to hospital and get the blessings of doctors. Right? On their advice he went. He has evaded such that 15 days have become 45 days, 60 days. He was happily in the hospital. Thereafter comes to the court and says, please read Anupam Kulkarni. You cannot send me to police custody. Supreme Court said, now the period will begin subtracting the evasive period. Supreme Court said, yes, we also accept. CBI versus Anupam Kulkarni has not foresighted all these criminals. People were then very good in 1992. Now we will subtract that evasive period and 15 days will start from afresh from the discharge. One day that fellow should be discharged if at all he is not meeting the maker. No, you should. This was laid down in Vikas Mishra. Subsequently, in Sandil Balaji case, court said, this is high time, Anupam Kulkarni has to be revisited. Right? And it said, there are two things. One is right to life and personal liberty of the accused. Equally important is justice to victim. Equally important is also the duty of the investigating officer. Courts are not there to infringe upon the duty of the investigating officer, who law believes that they are doing justice to the society. So, a division bench of the Supreme Court has referred the division bench of Anupam Kulkarni. Right? Now it is for a larger bench to decide. In between, what has happened, unfortunately to some people, BNSS has come. And 1st July 24 also is going to come. What BNSS is telling, 187 is telling, if charge sheet has to be filed within first 60 days, police custody will not be restricted for the first 15, it is expandable for first 40. If charge sheet has to be filed within first 90, police custody can be expanded within 60 days. If charge sheet has to be filed within 90 days, police custody can be given in an extendable time of first 60 days for a period of 15 days. I am repeating, this 15 days capping still remains. Why I am adding is, Honorable Home Minister Amit Shah in the speech in the Parliament clarifying for questions to one MP of one party, I do not know the name of the party, for whom he is telling that police custody is only for a period of 15 days and not more. But this drama of first 15 has gone. So you can expand it for first 40 days. Because they are acting under chest pain. Even a bypass, no, people are discharging in 3 days. You know that. Bypass has become like a pimple operation these days. But for high-stake criminals, no, it will extend. But it is not getting extended more than 30 to 25 days. So now the parliamentarians, they also know that better, because sometimes they also do that. No. So in Tamil they say snake's legs are identified by snake's legs. Right? Now this 15 days police custody is there. But elasticity of 40 days is provided for offences where charge sheet has to be filed within first 60 days. That is below 10 years. 10 years and above, charge sheet should be filed within 90 days. In that, you can give the police custody aram se within an extended period of 60 days. That's all. Don't confuse that. Don't misread that we are going to give police custody for 40 days. We are going to give police custody for 60 days. Because there is some small draft error in 187 which is giving a meaning like that. But all the constitutional courts, as we know, if at all they want to deliberate on this thing, they will also rely upon parliamentary debates. The Home Minister, this point was debated. Home Minister has said it is not the intention of 187 that police remand is extended for an extended period of 15 days. It is not like that. Right? Elasticity is provided. If somebody makes all these gimmicks in 15 days, it is 40. If he is going to make gimmicks in first 15, it is 60. Okay, that's all. This is with regard to 187. And 190, what is 190? It is pari material, it's 170 CRPC. I have told you yesterday itself this. Some charge sheets are filed under 170 CRPC where elaborate investigatory machinery is not involved. Prohibition cases, traffic cases, in that it says police need not 190 BNSS. In that, now it is said you need not insist for presence of the accused. Because Siddharth versus State of UP 2021 says Siddharth versus State of UP 2021 says, if a charge sheet is filed under section 170 CRPC, you need not harass that fellow by putting him in jail and granting bail. Okay. So 190 is this much. Coming to 193. 193, charge sheets can also be sent to the court in electronic form, such that the policeman will not come to meet your clerk. Right? More than that, I am not revealing today. Because Academy has given me an injunction. Right? So, see, so many harassments will be avoided. If a man lodges an FIR from his house, unwanted questions, redrafting of all FIRs. You know that every policeman will find a happiness in redrafting. This man who is the victim will go with one story. There will be an old head constable about to die or retire. That fellow thinks he is wise. What he does, he redrafts, sometimes thinking that he is helping the victim. What will happen now in the court? This head constable will not follow the case. 161 statements will be verbatim this FIR. Victim, many a times good people will come and say their version. What an advocate like me, defense lawyer will say, see, FIR one thing, information complaint one thing, FIR one thing, court version is entirely different. What the judge will say? The judge will use that one word I was telling, no, last para of the judgment. Right? An electronic FIR will save that also, that alterations also. There are many good things and bad things in every system. Then coming to 193, one important provision is 193 subsection 2 says, charge sheet for an offence under section 65 to 71, 64 to 71, that is all the rapes are grouped together, right? All these are grouped together. And now 193 subsection 2 gives a mandate to the investigating officer that charge sheet has to be filed in offences of rape and POCSO within one question. Yesterday also I asked who is the youngest magistrate. He was not caught still. Right? One question. I was just talking loud vociferously that about 187. Charge sheet if not filed, default bail within the period prescribed. Now 193 says you file a charge sheet for POCSO offence and rape case within 2 months. An advocate like CHANDRU comes and files a default bail application on expiry of 60th day, quoting 193(2). Advocates can also confuse, can also clarify. We have got two minds, no? Yes. But judges should be very clear what he will do. 193(2) says charge sheet for rape and POCSO offences has to be filed within default bail I am filing. Sir, this is a rape case. 193 subsection 2 is a new law. There is a mandate on the investigating officer. This is a special law over and above the provisions of 187. 187 generally says this is a special provision. Because Parliament has enacted it as a subsequent provision, they are aware of the previous provision. All this we will speak better, nicely, and confuse you. Whether bail should be given. Why? Yes. See, as Madam has rightly said, 187 only speaks of default. 187 speaks of the power of remand. If the offence is punishable more than 10 years, your power of remand continues for 90 days as per the dictum of 187. Now this is a direction to the fellow police that in these cases which are very serious, you should file the charge sheet within 2 months. If this man fails in filing the charge sheet, he will face the music. either through a superior officer or by the court. This will amount to dereliction of duty, that's all. Here it is nothing said about default. Since 193 subsection 2 does not address on default, it will not be in the teeth of 187. Okay, judges? So this is one intricate point with which many other academies were asking. So please don't get cheated. Right? Yeah, as human beings, no, the moment what we will think, yes, there is a charge sheet mandate, charge sheet not filed. For this default, should I release on bail? For this default, bail is not provided in this. For the default of 90 days and 60 days, it is provided in 187. Okay, honorable judges. Yes. Yes, we will stop the session. Sir, I will stop the session, sir. Stop the session for some time. We will resume by 12. Thank you so much. Then, section 193, subsection 2, we were discussing that for an offense of rape from 64 to 71, charge sheet has to be filed within 2 months. It is a mandate on the police officer, and for any dereliction of duty will be governed by separately. And that will not give the right for an accused to ask for a bail under default clause. Then, another important provisions are section 193, subsection 3. As soon as the investigation is completed, the officer in charge of the police station shall forward, including through electronic communication. It is inclusive now. It is not mandatory. Right? But he can also take that option. We cannot compel him that to file it in physical form. And to a magistrate empowering to take cognizance of the offense on a police report, a report in the form as the state government may by rules provide. Then subsequently, just come down, subsection I, the sequence of custody in case of electronic devices, because it should be in a proper custody. He should say how the custody of the electronic records are maintained. That is very important in order to avoid manipulations and material alteration. That has to be mentioned by him. Then coming down, H subsection 1, H subsection 2, that is also very important. Police officer shall within a period of 90 days inform the progress of the investigation by any means, including through electronic communication, to the informant or victim. This is one of the radical moves. We have started recognizing a victim, because I told they will just file it, they do not know what is the fate. Now investigating officer is duty bound to do that. And this also, non-obligation or non-discharge of this also will lead to dereliction of duty. In Tamil Nadu, we have got a law which is called as the District Police Act of 1870. The Tamil Nadu District Police Act. And there is also another corresponding law which is called as the City Police Act. I do not know whether you have got in Tamil Nadu. Those are 1870 Act. It says, section 21 says, it is in Telangana, pari materia. Telangana people told me they have gotten law. That is, any policeman who is in dereliction of his duty is punishable under section 21 is a dereliction, 41 is punishment of the City Police Act. Like that, if there is some act, you can catch him for dereliction without sanction, because sanctions are required if they commit an offense. You understand, dear judges? For commission of offense, sanctions are required. For commission of dereliction of duties, no sanction, because section 21 of the Tamil Nadu District Police Act, read with 44 of the Tamil Nadu District Police Act, for the district, for metropolitan cities, it is the City Police Act. So under that, our judges will catch them. Okay? If you don't have any law, you can ask your people to draft a law like that in your place. It is the City Police Act of 1870. In that, is there any dereliction of duty violation? Should see that, and you should also invoke. Then coming down, the officer also shall communicate in such manner as the state government may by rules provide the action taken by him to the person. The action taken by whom? to the person, if any, by whom the information relating to the commission of the offence was first given. So informant and the victim should be elaborated as to what I have done with the communication. Previously, what will happen, I will go and register an FIR, right? They will give a small chit. That is called as what they will say, we have dropped, right? And previous CRPC does not address with regard to anything called as protest petition. Protest petition. That is the only remedy which he has got already. That was also a judgment law in Bhagwant Singh versus Commissioner of Police, 1985 Supreme Court. Bhagwant Singh versus Commissioner of Police, 1985 Supreme Court. Bhagwant Singh. Bhagwant Singh versus Commissioner of Police, 1985 Supreme Court, which said that an informant has got a right to protest on the police dropping of the case. Suppose a complainant goes and lodges a case. The policeman, after investigation or before investigation, he drops it, right? The complainant has got every right to protest on that before the court by way of filing a protest petition. This was not in the CRPC. It was a judgment law through Bhagwant Singh versus Commissioner of Police, 1985, right? Those days were days, darker days. In the words of Prime Minister, this is Amrit Kal or Acha Din. Two things were said by the Prime Minister, no? Acha Din and Amrit Kal. No, I am not joking. See, you have kept a victim in darkness for 150 years. Only if that small receipt comes to his house, he will know that, oh, my case is dropped. Now, investigating officer is duty bound to inform within 90 days to the informant and to the victim as to what he has done. This is called as accountancy and transparency, right? So, all these are good things done by the Parliament. After all, Parliament is our reflection. Then, yesterday, prior to that, we will see 193.8 also. What is 193.8? Subject to the provisions contained in subsection 7, police officer investigating the case shall also submit such number of copies. Why? I told you yesterday when we were dealing about section 230. What is 230? Furnishing free copies. I told you free copies should also be given now to victim, victim's advocate, or if informant also insist, right? But it is said as victim. Now, 193.8 says such number of copies. Previously, if there are 7 accused, they will send 7 copies. Now, if there are 1 complainant, 1 victim, or multiple victims, each victim is entitled for a copy. So, 193 subsection 8 also has to be taken note of. Now, what I am anticipating, they will not give you any copy. They will give only an electronic copy, right? You should also press a button and send an electronic copy. Amma, email will be there. Yes. Then, yesterday we were discussing about further investigation, Vinubai, Haribai, Malavya, whether permission has to be taken, all those things we have elaborately discussed yesterday. Okay. What is the doctrine invoked by the Supreme Court to say that police should take permission? Contemporaneous expositio. Contemporaneous expositio. Contemporary possession of law. Okay? Yes? Now the law is 193 subsection 9. Changed law. Keeping in view of Vinubai. What does the new law says? Nothing in this section shall be deemed to preclude further investigation in respect of an offence after a report under subsection 3 has been forwarded to the magistrate. That is, after filing of investigation report also, charge sheet also, what you can do? You can proceed with further investigation. This is one thing. Then, and where upon such investigation, the officer in charge of the police station obtains further evidence, oral or document, he shall forward to the magistrate a further report or reports regarding such evidence in the form as the state government, ... right? Provided that further investigation during trial, yesterday we were discussing only about this, because court will go from Karnataka to Chikmagalur and policeman will go to Karnataka to Chennai. That is the reason it is said, provided that further investigation during the trial may be conducted with the permission of the court. Vinubhai Haribas Malavya, judgment. With the permission of the court trying the case, and the same shall be completed within 90 days extendable with the permission of the court. Now also see, there is also time frame. What will happen? Sometimes the investigating officers, to stop the case which is progressing, they will file an application for further investigation and halt the entire thing. What we will do? For report of further investigation, it keeps moving. Now it is 90 days or extendable period, means it should be with judicial reasons. Why it is extendable? Okay. So read Vinubhai also and read all these provisions also. I will ask you one question, right? What you will think, you have asked so many questions. Question is, policeman, Chandru gives a complaint as against Chandrika for something, right? Policeman dropped it, stating that it is a false case. Now Chandrika is happy somewhere that Chandru's case is closed. All the cases which are closed, sometimes the police will become wiser for many reasons, right? In certain period of time, they will close an FIR, and in a certain new different climate, what they will do? They will open. Question is, if at all a police themselves have closed an investigation stating that it is a mistake of fact, closed it once and for all, can they open it without notice to the accused? First question is, can they open it? Because the word investigation and further investigation, in a common understanding, further investigation is a continuation of existing investigation. Question is, police themselves closes, stating that I have closed the investigation. Now they are filing an application to the judge and telling that I want to do further investigation. Defense comes and says, since there is no investigation at all, or the investigation which they have started died, or they have put it to death, further investigation is not possible. What do you say? You understand the question? No. Whether the word further investigation or whether the aspect of further investigation is permissible only as a continuation of an investigation pending, or even if the investigation is closed by the police or the investigating agency, one fine day they can come up with a petition stating that I have found a new witness and new document. Can they say like that? Yes. You can write a judgment. State through CBI versus 2023. State through CBI versus Hemendra Reddy. State through CBI versus Hemendra Reddy, relying on Rama Chaudhary versus, relying on 2023 judgment, Supreme Court. Relying on Rama Chaudhary versus State of Bihar, 2009. Supreme Court says Rama Chaudhary versus State of Bihar, 2009. What is the proposition? Further investigation can be continued or can be sought for in a case which is not in existence or which is closed by the police. Okay. 2009, the Supreme Court and Rama Chaudhary said it is the domain of the investigating agency. They have closed it when they have no evidence. They are opening it. Good logic. Huh? Gee, when? Yes. Yes. 194. We have got only 1 hour and 45 minutes, right? The speed with which we are going is not like Vande Mataram. Vande Bharata. Yes, I am going like a old train. Amma Chennai Express. That too not Karnataka Express. Yes, section 194. Police to inquire and report on suicide, etc. Right? Subsection 2. 194 subsection 2, what is included is last lines 24 hours, time frame. That. (195) summons to power to summon persons. In that proviso, third line, 195 subsection 1 proviso, third line, acute illness was added. Previously also we saw that in which provision? 179 subsection 1 also we saw the same provision. Here also see the subsequent provision, proviso. Provided further that if such person is willing to attend and answer at the police station, such person may be permitted to do so. Here also the same thing was added. Okay, previously we saw 179 subsection 1 proviso, now it is 195 subsection 1 proviso. Then section 202 subsection 1, 202 subsection 1, the word electronic communication is added. Electronic communication, electronic message is added. Okay, in 202 subsection 1. Then 202 subsection 208. It is old 188. Right? 209 also, receipt of evidence relating to offences outside India, fourth line, either in physical form or in electronic form. This is an addition. Physical form or electronic form. 209, fourth line. Okay. Then 210. One addition is section 210. One addition is subsection 1, proviso A. Previously, it was upon receiving a complaint of facts. Now it is including any complaint filed by a person authorized under special law. Previously, a person cannot file a complaint under special law with magistrate. They should go to the special court. Now, it is including any complaint filed by a person authorized under any special law which constitutes such offence. Right? Then subsection B, 210 subsection 1 subsection B says, upon a police report within brackets submitted in any mode including electronic mode. Okay. Then 215 subsection 1 A Roman 3. The word included is last lines, other public servant who is authorized by the concerned public servant to do so. Previously the word was only public servant, now 215 subsection 1 small a Roman 3. Words added are other public servant who is authorized by the concerned public servant to do so. Now 218 prosecution of judges and public servants. Subsection 1, subsection 1 second proviso. Provided further that such government shall take a decision within a period of 120 days from the date of the receipt of request for sanction, and in case it fails to do so, sanction shall be deemed to have been accorded by such government. Now this is called as deemed sanction. You need not wait for a period beyond 120 days. Law says under section 218 subsection 1 second proviso, it says, provided that such government shall take a decision within a period of 120 days from the date of receipt of the request for sanction, and in case if it fails to do so, sanction shall be deemed to have been accorded by government. This is called a deemed sanction. This is one improvement in the present law. Okay. Then 219 subsection 1 proviso. 219 subsection 1 proviso. Provided that, it is a small inclusion, provided that where such person is a child or is of unsound mind or is having intellectual disability, all this is added. Then 212 also subsection 1 proviso. 222 subsection 1 proviso also, provided that where such a person is a child or unsound mind or intellectual disability. This is added. Then now we are in section 223, which our Deputy Director Satish ji told me in the morning to deliberate on that. 223 is almost pari materia with section 200 of CRPC. Okay, 200 CRPC is redefined as 223 of BNSS, right? First question is whether private complaints, check cases, 138 cases will be governed by 200 CRPC. Answer is no, because section 142 says, notwithstanding anything contained in any other law for the time being in force, cognizance should be taken under the right. One judgment of Sri N. Harihara Krishna, N. Harihara Krishna, N. Harihara Krishna versus J. Thomas, 2017. N. Harihara Krishna versus J. Thomas, 2017. Supreme Court says cognizance under NI Act, is not taken under 200 CRPC but under 142 NI Act. So, cognizance on a private complaint is not cognizance under either CRPC or BNSS, right? Otherwise, also in CRPC we take cognizance of offence. In NI Act we take cognizance of offender. There is also another distinction. In CRPC we take cognizance of offence. In NI Act we take cognizance of offender. And law 2017, a full bench of the Supreme Court says in Harihara Krishna's case, both are different. There is a special law provision for 138 cases, so you take cognizance under 142. So please don't imagine that in check case also from 1st July, if a check case was registered under some person, sir, you please wait, I will call the accused and accused superior. No, check case is an exception. So let us not get confused ourselves with a check case under the special law. Any law which projects a special law, you should immediately remember our mother-in-law and sister-in-law and daughter-in-law example, right? Yes. Then you should also read the judgment in INRI, expeditious trial of cases under 138 of NI Act. INRI, INRE, in the matter of INRI, RE, INRI, expeditious trial of cases under section 138 of NI Act. Right? In that, Indian Bank, in that also a case is referred by the Supreme Court, judgment of the Honorable Supreme Court in Indian Bank Association versus Union of India, 2014 Supreme Court. This INRI case is 2021. Indian Bank Association versus Union of India is 2014. Yes. Now I will tell you another thing. Firstly, I said, I told you two things. One is, NI Act cases are governed under NI Act. Cognizance is not taken by way of CRPC. Even though complainant puts it as 200 CRPC, cognizance is taken only under 142. This is the general understanding and also the law laid down in Harihara Krishna versus Thomas, J. Thomas. This is 2017. INRI, expeditious trial of check cases, 2021. notes another one case of the Honorable Supreme Court in Indian Bank Association versus Union of India 2014. What does it say? Indian Bank Association says a check case shall be governed by the provisions of summary trial. NI Act, even as per the NI Act itself, it should be a summary trial. This is one thing. Indian Bank Association Supreme Court says magistrate conducting a case under the NI Act should not mechanically convert it into summons case. So this is one rider. It says because the procedure prescribed therein by the legislature is summary trial, you should not mechanically convert it into, and if you have to convert, you should write reasons for that. This is what is said in this thing. Now, we will imagine, now you will convert it into summons case. Previously, there is no provision for discharge in summary cases. If Chandru commits a murder or rape or breaks somebody's head, Chandru can go to court and ask for a discharge. So, any accused should commit a sessions case or a warrant case for seeking for discharge. If you commit a grave offense, you can go on discharge. You need not undergo the pain of trial. If you commit small offenses, no summons cases, no discharge, very serious, very strict here, you should go up to the trial. Right? This was the law. What has happened? In 1992, K.M. Matthew versus State of Kerala. In 1992, K.M. Matthew versus State of Kerala, the Honorable Supreme Court has laid down a law that there is no need for any provision. Magistrate can drop the proceedings if he finds that there is no substance. Okay. This was in 1992. After 12 years, 2004, in Ruplal Jindal, in Adalat Prasad versus Ruplal Jindal, Adalat Prasad versus Ruplal Jindal, a 3 judges bench said K.M. Matthew is wrong because legislature has not provided any provision for discharge in summons case. Once legislature has not provided, courts cannot re-legislate and say in summons case you discharge. So K.M. Matthew versus State of Kerala said magistrate can discharge in summons case. Adalat Prasad versus Ruplal Jindal, after 12 years, it said nothing doing. And this 3 judges bench was once again confirmed by another 3 judge bench in Subramaniam Sethuraman versus State of Maharashtra. Subramaniam Sethuraman, C-S-E-T-H-U, Sethuraman versus State of Maharashtra, 2004 itself. Right? Now what has happened in present BNSS, legislature has relied upon K.M. Matthew, Parliament, and said any person can be discharged by the magistrate in a summons trial also. Okay? For this only I told you all this story. So now the law is, in a summons trial, you can discharge a person provided you feel that there is nothing in substance of accusation you have told him. Now come to NI Act once again. In NI Act, we have told you already, Cognizance is not under CRPC, Cognizance is under, yes. Now, Indian Bank Association says you conduct it as a summary trial. Summary trial, there is no discharge. Summons case, if you record some reasons and make it as a summons case, now new BNSS says you can discharge. Now you should follow Harihara Krishna, point 1. Cognizance should be taken under NI Act. You should follow see, Indian Bank Association, what does it say? You stick to summary trial and mechanically you should not come to summons case. So you should reveal your mind in the judgment that this is not a mechanical conversion. I intend to do so for the reasons stated here under, and I am converting into a summons case. Thereafter, you can now take asylum under BNSS and say this is a case which is fit for discharge. You understand, dear judges? So NI Act, only these things I think would have been ringing in your minds. I have clarified. If there is any doubt also, I will clarify. Okay. So I will sum up. NI Act cognizance is not under CRPC, under 142.1. Regular procedure is summary trial, point 2. That doesn't mean that judge should not convert it to summons case at all. Indian Bank says if need arises, you do that, but not by a mechanical order. Then new BNSS says for a summons case also, for grave punishment, for grave offences you are giving discharge. For this also, if there is a discharge, there is a want of discharge, you give that. Okay. For understanding any law on the question of discharge, you should start the story from Willie Slaney versus State of MP. Willie Slaney, Willie, W-I-L-L-I-E, Willie Slaney versus State of MP, 1951 Supreme Court. Then State of Orissa versus Debendranath Padi. These laws are settled proposition as to how discharge has to be made, under what circumstances. Willie Slaney versus State of Orissa versus Debendranath Padi, very famous judgment. Right? CBI versus Sajjan Kumar. CBI versus Sajjan Kumar. Then in 2020 also there is a famous judgment which is called as Shivalinga Murthy MV Shivalinga Murthy MV versus CBI Bengaluru, 2020 Supreme Court. In that read para 27 and 28. Shivalinga Murthy MV versus CBI Bengaluru, para 27-28 says discharge should be sought for by the accused only on the materials of the prosecution. So accused will not supply his materials. What he is asking, you have charged me through this material. There is nothing in that. You discharge on that. If he wants to focus something else, he should wait for the trial. Because the materials which the prosecution has given, court thinks that they are adequate to proceed. So in a discharge, the logic is, see, he is telling that you are charging. I want a discharge. Why? The material is inadequate. It is insufficient. Right? But those materials need not be adequate enough for entailing a conviction or an acquittal. Those materials would be sufficient enough for the court to believe that the manner in which the case was stated is sufficient enough to take cognizance. That's all. Prima facie. So, in normal sense, granting of discharge will be very, 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 very difficult. Because something will be there in the prosecution, this thing. You should see whether it is true or not only in the trial. So, discharges are very difficult to seek for and to grant also. To seek for discharge is very easy. To grant discharge is a very courageous act. Okay. Now we have seen what it is. Now, one word, cognizance, is very important once again. Have I explained to you yesterday what is cognizance? Yes. Cognizance means there are two types of cognizance. One taken under the police report. What is police report? It is otherwise called as charge sheet, challan. So, in a police case, in an institution of prosecution through police case, before filing charge sheet, there is nothing called as, yes, that's all. I am insisting, see, a judge will see the FIR first. What for? Remanding. A judge will see the FIR first when the accused is brought. Even though the judge applies the mind for remanding that fellow, This law says it is not taking cognizance because section 190 of CRPC, pari materia with 210 of CRPC, it says cognizance on police report. So, perusal of FIR, ordering for proper investigation, ordering for registration of FIR, handing over a person to police custody, rejecting police custody, returning the properties, whatever act, any other act you do before receiving a charge sheet, it is all not taking. Please don't forget that, because we always fail in this. This is one aspect which so many judges, they get confused. Cognizance is a process in a complaint on, in an information on, or in a process of police this thing. Cognizance is a process which is taken by the judge on the police report. Okay. Whether issuance of summons is taking cognizance. Charge sheet you receive, you issue summons. Whether does it mean that you have, is that taking cognizance? It is a post-cognizance process. That is the reason I am asking you the question. Issuance of summons is not taking cognizance because cognizance has been where? Here. Cognizance is a process which takes place here. It is that satisfaction which a judge arrives for summoning a person. The judge gets satisfied that on perusal of the papers, I am satisfied that I am taking cognizance of this case. That is a process which something happens in the mind. If the judge says issue summons, it becomes post-cognizance. Yes, my dear magistrate friends, have you taken note of? Issuance of process is not, cannot be equated with taking. Yes. Taking cognizance is different from issuance of summons. The moment you issue summons, it is understood that cognizance is already taken. Then, what are the duties of a judge if a charge sheet is placed before the judge? Point 1, accept the charge sheet. Point 2, reject the charge sheet. Point 3, order for further investigation. So, all these processes are with you the moment you take a charge sheet on file. Okay. State of West Bengal, please read this judgment very carefully. State of West Bengal versus Muhammad Khalid. State of West Bengal versus Muhammad Khalid, 1995 Supreme Court. Okay, now come once again to 223 because I have explained to you what is cognizance. Now come to 223. I will read this. 223 subsection 1 is the same which you will find in 200. 223 subsection 1 was already in section 200. Proviso. Provided that no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity of being heard. Now this tale has entered into 200 CRPC. What do they say? Provided that no cognizance shall be taken by the magistrate without giving the accused an opportunity of being heard. Now, I was telling you only about 190 cognizance. Cognizance on a police report. Now, cognizance on a complaint. Right? Tell me when cognizance on a complaint is taken. Chandru comes to the honorable judge. He is sitting as a magistrate. Chandru gives some 4 or 5 papers. Right? What is the next stage the judge does? Sworn statement, judge? Okay. Then recorded sworn statement of complainant witness. Then when cognizance is taken? After recording sworn statement. Okay. Judge, what do you say? How do you say that? You are all eating some chocolates, no? Give him more chocolates. He is right. Yes? See, I am giving you all good judgments which we should definitely take a printout and also have with you. He has said something that CHANDRU files a complaint under 200 CRPC to a magistrate or to a judge. The judge peruses the complaint. Like you peruse the charge sheet under 190 to satisfy whether you can summon some fellow. Now you are perusing the complaint for the purposes of taking sworn statement. This perusal of the complaint and getting satisfied that I am going to record sworn statement, that satisfaction is called as cognizance in private complaint. Okay? So, sworn statement is a post-cognizant process. I am repeating, in the private complaint, taking a sworn statement is a post-cognizant process. Wherefrom I say all this is Emperor versus Saunindra Mohan Chakrabarti 1910. Emperor versus Saunindra Mohan Chakrabarti, Calcutta, Allahabad Division Bench. Okay, Emperor versus Saunindra Mohan Chakrabarti. This is 1910 Division Bench, Calcutta High Court. Thereafter, in Gopal Marwari versus Emperor, Gopal Marwari versus Emperor, 1943 Patna High Court. Gopal Marwari versus Emperor, 1943 Patna High Court. Then, another famous judgments where you can understand what is cognizance is the Superintendent and Remembrancer of Superintendent and Remembrancer of Legal Affairs, Remembrancer of Legal Affairs versus Abani Kumar Banerjee. 9/5/1950 Calcutta High Court. 9/5/1950 Calcutta High Court. Superintendent and Remembrancer of Legal Affairs versus Abani Kumar Banerjee, 1950 Calcutta High Court. Right? This legal remembrancer case was approved by the Honorable Supreme Court in R.R. Chari versus State of UP, 1951. R.R. Chari versus State of UP, 1951. These judgments are for what thing? Understanding what is a cognizance in a private complaint, what is the cognizance in a police report. In 1910, this Emperor versus Saunindra Mohan Chakrabarti, beautifully two judges have said, see that 1910 judgment is alive till date. That 1910 was followed in Abani Kumar. Abani Kumar was stamped as a good judgment in R.R. Chari. R.R. Chari is followed by the Supreme Court till date. You understand the amount of truth with which the judgment was written, or the sincerity with which the judges have written. You people will never die, you know that. You are all immortal in one sense. How? Judgments will be alive. Judges never die. Right? You all live through your judgments. And if the judgment is very sincere and it contains truth, it will live until the earth is there. I honestly envy and appreciate. I was envying the judgment of 1910 the moment I read that. What I thought, what should be the conviction of the judges in interpreting section 200? Because in 1910 means 1861 CRPC came. Right? After 50 years, till 50 years it was not settled. But two judges of the Honorable High Court, Calcutta, with some conviction and truth and understanding of law, they have propounded a law which still stands good. No, it is all envious, no? Usually man will envy on other man's property, other man's jewels, right? I envy persons who are very honest, who are very intelligent. That is my envy. I envy that God has created that fellow as a real human being. This should be our envy, no? These judges are, see, that we are talking about those judges, 1910. You read that judgment, beautifully they say, taking cognizance under section 200 is perusal of complaint and getting satisfied for the purposes of recording sworn statement. These portions are all doubtful for so many judges. Even I have seen high court judgments where they have used the word loosely for taking cognizance. This word taking cognizance will be used by many high courts very loosely. Right? Then these judgments were followed by one judgment of 2006, State of Karnataka versus Pastor Raju. State of Karnataka versus Pastor P. Raju, 2006. Then State of UP versus Parasnath Singh, 2009 judgment. Then State of UP versus Parasnath Singh, 2009. Then the famous judgment of Subramaniam Swamy versus Dr. Manmohan Singh. It has elaborately discussed about cognizance. Right? In that also, legal remembrancer judgment after 1950 and Chari judgment was discussed. Right? Subramaniam Swamy versus Dr. Manmohan Singh, 2011 judgment. Right? Now, having understood what is cognizance, okay, I want some answer from my dear magistrate children sitting behind. Having understood what is cognizance, now a man comes under section 223 on a private complaint. Okay, now we will read 223 fully. Examination of complainant, 223 section. So magistrate having jurisdiction while taking cognizance of an offence on complaint. What is this complaint? What is complaint? Section 2D says there is a marked difference between information and complaint. Information is one that is given to, yes. 2D complaint says an allegation to the magistrate either made in writing or oral that a person known or unknown has committed a crime with a view to take an action by the magistrate. 2-3 things. A complaint is an allegation made to the magistrate as against a known or unknown person. What for it is given to the magistrate? With a view to take action. If these three are satisfied, then it is a complaint. Okay? Yes. Now, 223 says a magistrate having jurisdiction while taking cognizance of an offence on complaint shall examine upon oath the complainant and the witnesses present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the person, shall be signed by the complainant, the witnesses, and also by the magistrate. Now, provided that no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity of being heard. Now, down. Provided further that when the complaint is made in writing, the magistrate need not examine the complainant, and these are all same things. What another is added is subsection A. If a public servant acting, then beyond that, then under that, subsection 2. Subsection 2, a magistrate shall not take cognizance on a complaint against a public servant. Right? As against a private individual also, if a private complaint is filed, one second. As against a private individual also, if private complaints are filed, no magistrate shall take cognizance before hearing the accused. That is, as per the judgments of Saunindra, Pastor Raju, what you should not do, judge? You said rightly. That means you receive the complaint. That's all. But it should reveal that I have taken cognizance. Docket should reveal that I have taken cognizance. Huh? Should not. Why? Provided that no cognizance shall be taken. Yes. That is what law says. Right? But the absurdity in that is, every magistrate or judge is expected to take cognizance. Then only you have applied your mind and got satisfied that I am stepping to the next stage. Here it says, provided that no cognizance. See, is it not absurd? If you don't take cognizance on the complaint at all, how do you arrive at a satisfaction that I can call the accused for hearing? See, calling the complainant for sworn statement or calling the accused for hearing, you should have taken cognizance first. But law says, provided that no cognizance shall be taken without hearing the accused. But law is law. Right? So any private complaint comes, once again also, I think it is clumsily drafted. Intention is, through a private complaint, a proposed accused should not be harassed. Intention is good. Drafting has to be amended, that's all. Intention is good. What parliamentarians are feeling, these private complaints are eating away eating away court's time, and also people take it as a vengeance measure. See, a lot of private complaints ends in an acquittal because mostly it is all false. Mostly, not every. See? You just make a private complaint, that's all. Now it says call that accused. If you hear the accused and you find that it is false, you need not take the pain of putting the, see, one good thing is you need not even take the pain of putting the complainant in the sworn statement, right? So we will see how it is all working, right? See, subsection 2, if it is a public servant, morning itself we have seen in which provision? Morning we have discussed, if a public servant, if a case against a public servant is given, 175, subsection 3. What we said, in a failed attempt for registration of affair, if he comes for an application to magistrate, then the public servant should be heard along with a report. Same thing is reflected in 223 subsection 2, subsection A and B. Any doubt? Amma? That is the reason I told you, the word heard is also used in the context of discharge. See, discharge application also, the word used is, the accused shall be heard on the charge. Now also they say that he shall be heard on the complaint, right? Now the second question comes is, whether the word heard will amount to permitting the accused to file counter, permitting him to file documents. All this we have to wait and see. Because hearing the accused, we have understood that word heard all these days, that he shall be heard, that's all. On the basis of the complaint, exactly. On the basis of he should come and say whether the complaint is bad or not. Suppose he has a better evidence, then, see, suppose somebody says Chandru has committed an offence in Karnataka, right, on 17th and 18th June. Chandru on 17th and 18th is in United States. Why Chandru should be prevented now? When you give an opportunity to be heard, he can be heard better in support of a document. But that law, no. In India, that law we have never developed. No, the alibi is different, sir. I am telling that if I have got a better evidence.
Then we take a report from superior.
No, taking superior, it is only with regard to governments, public servants. With regard to ordinary private persons, see, there is some injustice in that. For a private person, why you should deprive him a report? If you are having, if you are giving some, this is violative of Article 14. No, discretion of the court means law says, calling a defendant for filing a return statement or calling an accused to enter upon a defense is different from calling him for hearing. We'll wait for some judgment, that's all. Or some of you permit the accused to file counters. Or some, I'm not joking. See, definitely we will do something. No, see, you cannot take cognizance. Yes. All these questions, no, we are asking with the mind of the previous laws. Previous laws have not permitted us to look into the records of the accused. Now this is a stage where you are permitting to call the accused itself before taking cognizance of the complainant's case. My doubt and anguish is, without taking cognizance, how can the judge know that there is something in the complaint? There should be some this thing, and some judgments will come. Some magistrates will write beautiful judgments. It will go up to the... I cannot say like that because there is no express provisions. I as a resource person has got some limitation. I cannot say that this position can be equated by calling an accused to file a written statement. Right? That is participation in a trial. Here they use the word, you see, had Parliament's intention is asking the accused to come with a report or papers, they would have used that word. Because they are using such word when it comes to public servants, what are they doing? We will hear the accused, but we will call for report. So there is some distinctions. Has to be by the words. But please wait, our magistrates friends will write beautiful judgments. I am not joking. See, I am telling you one thing. So many Supreme Court judgments, no. It will affirm the judgments of the munsifs and magistrates. You have known that. It will go to Sessions Court, High Court. There, Supreme Court will say the view of the trial judge is correct. No, they are very pure, good people, clean-hearted people. Innocently they come, no. They do not know anything. They don't worry about anything. They worry about justice. See, so many government servants at the outset, at the very beginning, no, they come with a very clean slate. And slowly we will poison them. Oh, you have written like this, finished. You should have written only like this. Right? (227) Subsection 1, small b, proviso. Provided that summons or warrants may be issued through electronic means. Why this word may is there? Optional. If you have the facility, kindly do that. Save papers. Right? See, environment wise also, you can just do that. We can save a lot of papers. So please also try to implement the new laws. 229, special summon in petty case, subsection 1 proviso, fine is improved to 1,000 to 5,000 rupees. 229, subsection 1 proviso, fine 1,000 to 5,000. Then 230 is equivalent to section 207 CRPC. Morning we have discussed. What I want to say you is, gone are the days when state will come and say, prosecution and investigation will come and say, we will give only those copies on which we are relying. Now the Supreme Court, in 2 or 3 cases, it has given a direction that any material that the investigation officer collects shall be given to the accused. Why? Logic. What is the purpose for trial? Doing justice, finding truth. It is not to support the false case of the police, or it is not to support the prosecution and send him to jail. And the solemn duty of prosecution is to see to that the materials collected by the investigating agencies are properly presented before the court. And defense is to see to that if at all he is innocent, he should be saved. And duty of prosecution is, if at all he is a real person who has committed the offense, to put him in jail, right? Now, depriving the accused that, for example, Chandru has committed an offense. Police comes to Chandru's house. Where will be the evidence, better evidence? Chandru's house. They collect everything. Then they will become like swans. They will only, what they will do? Separate milk from water. What evidence they will rely? The evidence which is against Chandru. Now Supreme Court says, gone are the days, whatever you collect from by investigation, give it to him also. Suppose if it is advantageous, he can prove that he is innocent, he will produce it. Okay. Judgment is Manoj versus State of MP 2021. Manoj is a State of MP 2021 Supreme Court. Then Ponnuswamy versus State of Tamil Nadu. Ponnuswamy versus State of Tamil Nadu. 7/1/2022. Then INRI, issuance of certain guidelines. INRI, INRE. INRI, issuance of certain guidelines regarding inadequacies and deficiencies in criminal trial, 2019. Right? These three judgments says an accused is entitled for copies INRI, issuance of certain guidelines regarding inadequacies and deficiencies in criminal trial, 2019. Supreme Court has given various guidelines. Take all this judgment. In nutshell, it says an accused shall not be deprived of materials collected by investigating agency. If something is favorable for him, it should be given to him. Okay. So free copies, I have already told you, free copies. See, I am reading the relevant portion. In any case, section 230, in any case where the proceedings has been instituted on a police report, magistrate shall without delay and in no case beyond 14 days from the date of production, 14 days time frame for free copies. Free copies, 14 days. 14 days from the date of production or appearance of the accused, furnished to the accused and the victim, in bracket, if represented by an advocate, free of cost. That doesn't mean that if victim does not get represented by an advocate, victim alone comes, you should not say no. The reason for drafting like that is, if at all the victim has already filed in advance an application under 18 subsection 8, you can give it to the advocate. Or on application, you should definitely give the victim the free copies. Okay. This is one mandate. 231, in committal proceedings, fourth line, 231, the magistrate shall forthwith furnish to the accused free of cost. Okay? So, committal proceedings, magistrates should be very careful that free copy should be given forthwith. What is forthwith? Immediately. It is not even within a one day or 2 days, immediately. Then 232, I have told you yesterday itself that committal proceedings should be committed within 90 days, extendable up to 180 days, and any application filed by any person, where it should go? Sessions. I told you yesterday all this, right? The intention is committal proceedings should not be held by the magistrate for a long time. See, there are a lot of committal proceedings pending before magistrates court for years together. Right? Huh? For proclamation, absconding. Split up it under section 317 and send it. That's all. Then section 242, subsection 1, words added in the last lines are any number of them not exceeding 5. Previously it was 3. Offences of same kind within the year may be charged together. Previously it was 3, now it was 5. That addition was made. Then, opening case for prosecution, 249. Trial before a court of session. Okay? Trial before a court of session. How many of you are district judges here, sessions judges? All. First row. Yes. Judges, I have got a doubt. There are only 2 types of cases. It is only for district judges. There are only 2 types of cases. Summons case, warrant case. But as session judges in cost title, you are printing a sessions case. You are empowered to do that. You can do that. But what is that case also? See, why I am asking you is, that is there. Thing is, law says, law defines only 2 cases. Summons case, if punishment is more than 2 years, it is warrant case. Now, chapter 19 says, trial before a, that is, it is a trial of warrant case before a sessions court. Unless and until some of your rules says that it is a sessions case, CRPC is silent on that. It is not at all, it cannot be called as in the teeth of CRPC. It is a trial by a sessions court of a warrant case. Okay? See, CRPC is silent. If somebody asks you that, if it is permissible, it is good. In many places, it is not there. Criminal rules of practice differs from state to state. But it is good that they have already given like that. Otherwise, it is trial of a warrant case by a sessions court. Right? Then, opening case for prosecution. Do you practice, especially session judges, do you practice a procedure called as pre-trial conferencing? Yes. Exactly what are you doing? Whether all the judges are doing. Whether we should do or we should not do. Why? Supreme Court has directed. State of Kerala versus Rashid, please write. State of Kerala versus Rashid, 2018. State of Kerala, you just put a caption, pre-trial conferencing. Then 2019, Mallikarjuna Kodahalli, Rashid. Then Mallikarjuna Kodahalli versus State of Karnataka. Then INDRI assessment of criminal justice system. INDRI assessment of criminal justice system in response to sexual offences. One is Mallikarjuna Kodagalli, second is State of Kerala versus Rashid, third is INDRI assessment of criminal justice system in response to criminal offences, 2019. Then INDRI certain guidelines regarding inadequacies and deficiencies in criminal trial versus State of AP 2021, that you have already written. All these 4 judgments of the Honorable Supreme Court insist on a process called as, one fine day Supreme Court will take contempt. Why? From 2018 they are telling that, what? Yesterday, I had the privilege and honor of discussing something with Honorable Justice A.V. Chandrasekharan. My lords have dealt on this in the year 2016 itself. I was astonished. I learned one thing yesterday, that this was already discussed by a Honorable Judge of your court. NR Bhatt is a CBI, 2016. Please note, take a copy of that. I have learnt that from my lordship, that I was under the impression that pre-trial conferencing was invented by the Supreme Court in 2018. But there are stalwarts here who has already discussed. Right? 2016, NR Bhatt versus CBI 2016, your Honorable High Court has given a direction that pre-trial conferencing, it is nothing. You call the accused, you call the complainant, you call accused counsel also, and there is a triangular meeting for an understanding, firstly, what is the case? Whom are you going to examine? Who are real material witnesses? What are real documents? Which documents has to be admitted and marked? Which documents you are going to contest? And cross-examination will be done in which pattern? Because there will be 10 eyewitnesses. What police will do? They will bring 2 witnesses. What a defense lawyer will say? My lords, I will cross all of them together. When this will happen? Now, if you sit together and work on the case, you have to work on the case, because there is a direction by your High Court also. Work on the case. Definitely you begin a case, you can end it within the session. You know what is the meaning of sessions case? Now I am in forenoon session. After lunch, somebody will be on afternoon session. Session is a given point of time. There is a beautiful article I saw in my Madras High Court, this thing, that British people, when they go in a camp court previously, some 200 years back, sessions cases will be finished as a session. One session. That's all. So they begin, finish. One sitting, one session. This is the whole meaning of sessions case. It is not keeping a sessions case for decades. Session means forenoon session, afternoon session, right? Or weekly session. That's all. You start it, finish it. This is the intention of the word session. And Supreme Court, to further it, and my lords also, Honorable Justice A.B. Chandrasekharan also has deliberated, I think it is in para 38 and 39 of the judgment. Right? Please read that and get enriched such that the moment you start a case, you will definitely finish. Now, in the pre-trial, the accused counsel will also say, I will do it in this pattern. I will do it in this fashion. There is also a binding nature. Suppose tactics are followed, one weapon in your hand is 309. Any tactics which either of the persons makes, what is the weapon in your hand? 309. 309 CRPC, you can put cost on the prosecution witnesses, issue arrest warrant for witnesses, and if accused is making dilatory tactics, what you can do? Cancel the bail and keep him in the place which is due for him. Right? You can read judgments in Raj Dio Sharma for 309, Raj Dio Sharma versus State of Bihar. Raj Dio Sharma versus State of Bihar. There are 2 judgments, 1 and 2 in Raj Dio Sharma. Then, State of UP versus Shambhunath Singh 2001. State of UP versus Shambhunath Singh. Then, what is the another famous case? 2014. Vinod Kumar versus State of Punjab. All these judgments says adjournment should not be granted on the drop of the hat for every reason, right? 309 is presently has become 346. Now 346 has teeth to bite. What do I mean? Previously 309, to enforce 309 is very difficult. Now 346 is pari-materia of 309, which says 346 subsection 2 fourth proviso. 346 subsection 2 fourth proviso says no adjournment shall be granted at the request of a party except where the circumstances are beyond the control of the party. 2b, where the circumstances are beyond the control of the party, not more than 2 adjournments. That is, courts are given a limit not to grant. What honorable courts will say henceforth? If third application comes, you cannot, because we are not potent to do that. Law says, whatever the reason be, or any reason beyond his control, this thing can be granted adjournments, that too after giving notice to the other side and reasons to be returned. Beyond 2, you cannot do anything. Okay? This is what the intention of 346, which is previously, yes. Then discharge. So opening of prosecution means it is also inclusive of pre-trial conferencing. That is the reason I am insisting upon. One fine day Supreme Court will issue a contempt. And we do not know who will be the scapegoat for that. No, see, they are repeatedly telling from 2008, you should definitely do a conferencing which is scientific in nature. Honorable Lordships yesterday told me, Chandru, if judges follows this pre-trial conferencing, definitely they will finish cases. He asked me a question, why is that cases are pending? I said, Lordship, because of what? Pendency. He said, lack of planning. And he immediately told me this pre-trial conferencing. So we should try methods which are devised by greater wisdom already. Right? It is all, after all, for the interest of the institution. Discharge. All discharges, that is discharged by a sessions court and magistrate court or any other court, now discharges are time bound. Discharge application should be filed within 60 days. Why? Why? How they will drag, you know? 10 accused will be there. One by one will file for 10 years. And this first 10 years will take another 10 years. And the last accused, no, if he files in the 100th year, it will become 1000 years. The honorable judges, you would have seen cases. A1 will file first. And then he will try the luck. A2, then if it will go up to the Supreme Court, it will get discharged. He will put some more grounds and he will try the luck, A2. Now any discharge by any of our dear accused has to be filed within 60. You can beautifully say that beyond 60 days I cannot entertain this. Let them go. Now the happy thing is, so many litigations will come, advocates will be very happy. Each law has to be settled. 1861 we are settling it up to 2023. Now 2023 we will settle it for another 200 years. Beautiful, so many new case laws will come. Each high court will say one thing and all will go to the Supreme Court. We will enjoy that. Okay. So discharge is within 60 days. Framing of charges has also to be done within 60. How it is possible? Is it possible? Yes. Answer is, if he fails to file a discharge on the 60th day, you should be ready with framing of charge. Suppose if the accused files an application or a memo that I am not going to file a discharge, you can frame charges on any day. So you have a mandate to ask, you have a right, you should say that you have a right to file a discharge within 60 days. What do you say? If he says, yes, I will file, definitely they will drag. On the expiry of the 16th day, you have to frame charge because you should be ready by that time, right? This was mandated in Court of Sessions case and also warrant cases. 254 says witness, evidence of a witness under this section may be recorded by audio, video, electronic means. Then deposition of any public servant may be taken through audio, video, electronic means. This is 254. 258. Judgment should be delivered within 30 days from the date of completion of arguments, extendable up to 45 days. So what hereafter the docket will say? The moment argument is closed, judge has got a mandate to deliver judgment within 30 days, extendable up to 45 days. This was given in view of the judgments of two judgments of the Honorable Supreme Court, one in R.C. Sharma versus Union of India, R.C. Sharma versus Union of India, 1976, then Anil Rai versus State of Bihar, 2001. R.C. Sharma versus Union of India, 1976, Anil Rai versus State of Bihar, 2001. These two judgments have already held that judgment should be time-based. Right? Now this has become law. Now we should not think of devising method for clarifications, for arguments. If we keep on doing like that, then another amendment will come. Clarification should also be heard within period of 10 days or 5 days. Okay? So don't leave the parliamentarians to rework on that. This is 258. 260. Fine amount is exceeded in section 260. Fine amount is exceeded from 10,000 to 50,000. Sorry, 1,000 to 5,000. 260 subsection 4. Then chapter 20 is verbatim. Same changes which were made in the sessions cases were made in trial of warrant cases. The same 60 days, same examination through audio video means. And one thing, 265, evidence for prosecution. Last lines, 265, provided further that the examination of a witness under this section may be done by audio video means at a designated place notified by the state government. I have told you yesterday, nobody will come to your court. Witness will sit in a designated place. What is the judgment already? Smruti Tukaram Badade. Smruti Tukaram Badade versus State of Maharashtra. Yes. Smruti Tukaram Badade versus State of Maharashtra. I will let to amendment. It says, it speaks about VWDC, that is Vulnerable Witnesses Deposition Center. So the concept of setting up of deposition centers was already there. Supreme Court has already spoken. That was only for vulnerable witness. Now what will happen? We will be removed out of that. Witnesses deposition center. Right? They will depose from that place. That's all. Then 269 subsection 7 is a new introduction. 269 subsection 7 is a new introduction. What does it say? Where despite giving opportunity to the prosecution and after taking all reasonable measures under this Sanhita, if the attendance of the prosecution witnesses under subsection 5 and 6 cannot be secured for cross-examination, it shall be deemed that such witnesses has not been examined for not being available and the magistrate may close the prosecution evidence. So please note this also. If the witnesses are dragging, prosecution witnesses, then court can close it as mandated under 269 subsection 5, 6 and 7. Then what happens if absence of complainant, 272. If complainant is absent, when the proceedings have been instituted upon complaint and on any day fixed for hearing of the case, complainant is absent and the offence may be lawfully, see, you cannot close all the complaint. Two things, it should be compoundable offence, it should not be a cognizable offence. Then you can give a notice for 30 days to the complainant and discharge the accused. 272. 274. Yes, Ji, please. Ji.
But 260, 271,
2?
71, warrant trail.
Okay.
Limitation is not stated to pass judgment.
So you want to say that it is only for trial sessions cases?
Yes, yes. Whether it applies to warrant trail before the magistrate.
You are referring to other provisions, what it is, Ji?
271.
It speaks of acquittal or conviction.
Yes,
So you want a specific provision for that?
yes.
Excellent, Ji. You have found out the method now itself. Super, Ji. See, I have already told you 2 judgments. Those judgment doesn't speak of warrant case or trial case. Those judgments have also said in civil cases also you should finish 30 days. And those Supreme Court judgments are also law of the land. But I appreciate you. Who is that?
Yes.
See, you are a prosecutor, no?
No. Judicial officer. No. In criminal rules of practice, 14 days is fixed to pass judgment in criminal cases.
See, now what is the judgment? After Satyendra Kumar until 2022, Satyendra Kumar until versus CBI 2022 prescribed for disposal of bail applications within 2 weeks, anticipatory bail within 4 weeks. Now, in both Supreme Court and the Parliament, they are making all these time frames to see to that some of the cases moving. But I am an advocate, I can talk frankly. The same Parliament and same Supreme Court also should see the pendency of cases, availability of infrastructure and the cry of a magistrate. You are using one man for dying declaration, for 164 statement, for protocol and what not. Legal, everything, and Saturday, Sundays we eat for some reasons. These people also have families, right? Their wives should not come and stand in family courts. What reason? Husband. What reason? I have never seen my wife or husband after joining judicial service. See, I am not joking. Government should also see that these judges are human beings, right? All Saturday, Sundays goes on some pretext. Legal aid, what is that? Many things, and academy works, right? All judges invariably know, they all become either sugar patients or BP patients. Nothing, see, just by celebrating one yoga day, nothing will happen. It is an expense to the state, that's all. Judges should be given some time to do yoga every day, right? They are also human beings. What is the infrastructure we have got? See, what is the infrastructure? One magistrate is taking care of 2 or 3 courts, and poor public prosecutors are handling 2 or 3 courts. Morning they should go to one court, Monday they should attend one court, and Tuesday they should go 200 kilometers for another court. See, all.
That's why they should find out a route, okay, by doing some smart work. See, magistrates, they have got various options to discharge the case, okay, in that way.
Madam, if they discharge the case,
Some cases, they
CJM is the first person to catch them. Subsequently, PDJ will catch.
see someone's cases, okay, where the witness complainant did not turn up, they should drop. All these procedures are there, they should make use of it. And see that some genuine cases are maintained with them and they have got enough time.
I appreciate madam. I also feel that magistrates under madam will be very blessed and happy. Why? See, there are certain CJMs.
Sir, every now and then local alert comes, comfortable cases. They should make extra effort to see that more number of cases are disposed by way of compounding method. See, this way, if they do some exercise or the smart work, their pendency are
Can be reduced.
They get enough time for themselves also, and they can
Yes, this is a good suggestion, but infrastructure has to be expanded. More officials has to come in. Appointment of too many courts should be there. Construction of courts, no, and diversification of work should be there. It all should be there. You cannot run a state with 1,000 judges. Madam, 75 years of independence, madam.
We got good governance now only, sir.
Every time we will have some good governance, right? But my worry is because judges are kind enough to call me in academy, I have understood that in Tamil Nadu also, there are 1,200 judges, 7 crores of population. What is the percentage with which it is made? 7 crores of people, just 1,200 judges. See, they are all gods. They are doing miraculous job. You cannot see a man or a woman judge going to school with their children, right? I had the happiness of going with my father thrice in a day for school. Morning, afternoon, once again afternoon, evening. After coming and meeting you all, no, you are all really working for the system. You are all like candles, you are dying for the system. Right? That is the reason I am telling you are all immortal. Have you ever had time to hug your small child? Not even on Saturdays, Sundays. You, after every work, you go to home by 8 o'clock, only to sleep in the bed, that's all. You cannot do anything else. You feel drained, no? Right? See, they have not hugged their children. I am honestly telling. What he will do at the age of 60 or 62, you will sit in an easy chair with the tablets around, right? You will not even have the power to run behind your daughter-in-law. Sorry, what is that? Granddaughter, not daughter-in-law. I am extremely sorry. Okay, note it. 392(1).
It doesn't make any difference between a sessions trial or a warrant trial.
That is the common provisions. 392. Excellent, judge. Also note down. It starts with that. See? Yes, no time limit earlier. I have noted that. Yes. Excellent, judge. Judge, you can now become no. You are a district judge now? Yes. So, see the amount of vigil he is maintaining. He wants judgment to be given in time. Amma, yes. Substance of accusation to be stated. This I have dealt in elaboration, right? Summons case. It is substance of accusation to be stated. In a summons case also, you can now proviso. Provided that the magistrate considers the accusation as groundless, he shall, after recording reasons in writing, release the accused, and such release shall have the effect of discharge. Then non-appearance or death of complainant. 30 days time is inserted, G. It is in section 279. Then summary trial. Certain offences are mandatorily to be tried in as summons procedures, right? Beyond that, it is nothing is there in that. Then application for plea bargaining. That is 290, 291, 292, 293. I will tell one thing about people, about some judges, if you do not know what is plea bargaining, it is different from pleading guilty. Pleading guilty is he goes and says, I have committed, you can punish. Now, this is not pleading guilty. In a way, he is pleading guilty, but he is making a bargain for the sentence. See, understand this. In plea bargaining also, he pleads guilty consciously, he files an affidavit that I have committed the offense. But in pleading guilty, he cannot read the mind of the judge. A judge will be looking very smart, very nice like me, very fruitish, right? Yogic. Madam adds me another one word, yogic. But the moment he filed a pleading guilty petition, judge will say, yes, you are caught, my son, because I think it is Chandrika versus state of UP, not that Chandru and Chandrika. This is real Chandrika versus state of UP. Supreme Court says in Chandrika versus state of UP, you cannot purchase what? A flea bite sentence. The word used is, by making a pleading guilty petition, you cannot purchase a flea bite sentence. That is a small sentence. That, see, court arrives at a conclusion that the man is guilty. Now this man, by filing this petition, is dragging the court to that conclusion. Only one thing is whether this man knows what is the offense. Point 1. Any man who files a pleading guilty petition, court should make sure that this man knows what is the accusation against him. Point 1. This man knows what is the severity of that. This man knows what is pleading guilty in real substance. If he files a mechanical typed out petition, sign it and give, you also say pleaded guilty, I am sentencing him, it will go to the High Court, it will get struck down that it is violative of Article 21, because your mandate of explaining him that you think of and come reflection time all should be given. In pleading guilty, if you don't give a reflection time, you should explain that this is an offense, you are pleading guilty, you have got a right of trial, right? And all this should be in docket, such that if it goes to the High Court or Supreme Court, court will say, he has told the court that he wants to pleading guilty, but court has said, this is an offense, this is the punishment for that, if you plead guilty, you will be punished, you have an option to be tried. All this, if it is explained, and over and above, if he says, no, I am pleading guilty, you can send him to jail. And this concept of pleading guilty should not be given for offences which are warrant trial in nature. Why? If it is grave in nature, if he pleads guilty also, what you should read? You should read that judgment of General Vaidya's case. General Vaidya's case. Sukhdev Singh was a state of Maharashtra. Sukhdev Singh was a state of Maharashtra, famously called as General Vaidya's case. What does it say? Sukhdev Singh's case, this General Vaidya was the person in key charge for this golden Blue Star operation, Golden Temple, right? This Sukhdev Singh, after this man's retirement, General Vaidya, he followed him, came to Bombay, and when General Vaidya was going with his wife in a car, point blank they fired him, he died in the car. This Sukhdev Singh, after arrest, right from the stage of furnishing a free copy till written arguments, he is committing in writing that I have committed this offense. But unbothered about his pleading guilty, the trial judge proceeded with the trial. Supreme Court said, in grave offences, if a man pleads guilty, principle of natural justice and criminal procedure court warrants a fair trial, it should go along. But in each stage, you should record that this fellow is pleading guilty. In cross-examination also, they will go and say, what is Godse's case? Godse was telling, I alone did that. Nobody else did that, because along with him some 20, 30 people were added. He said, I have committed the offense. In that case also, you should get along. In cross, what he will write? This man doesn't want to get crossed. He pleads guilty. 313 also what he will say? Yes, I committed the offense. Along with that, you should appreciate the prosecution evidence. If it still instills confidence, you should arrive at the question of guilt or acquittal. Okay? So, pleading guilty is something. Coming to plea bargaining. What is this plea bargaining? He is making, see, we are all experts in bargaining. With whom? Poor ladies. Poor old ladies. Underline the word poor old ladies. Capable of not arguing. Right? What we will do? We will show all our economics, all commerce, all revenue intelligence with that old woman who carries vegetable in the, go to mall, close all this, and that fellow will charge us heavily to maintain our dignity, because we are going in a court and all, no? So we'll just close our mouth and purchase all substandard things and come to the home. This lady is supplying all good vegetables, fresh, real organic, because she will not have the money to put any fertilizer in that. Right? Now the plea bargaining is making crosswords in a dialogue manner. I have committed this, then complainant will come, judge will also be there. Now this is not applicable for offences against women. This is not applicable for offences against child. This is not applicable for socio-economic offences. This is not applicable for any offence which is punishable more than 7 years. Woman, child, socio-economic offences, offences which are punishable more than 7 years. Right? Then, both have to arrive at a mutual disposition. It is purely mutual. On the acceptance of the complainant and the accused only, it will be arrived. Okay, Probation of Offenders Act also can be invoked, provided if it is invoked. Then another thing is, if there is a minimum sentence, what is this word minimum sentence prescribing? I told you two sentencing. One is persuasive, another determinate. Minimum sentence means determinate sentence. That is, legislature would have already said, this is the minimum sentence. If any minimum sentence is prescribed, then he can bargain up to 1/4. If there is no minimum sentence, he can bargain up to 1/6. Okay? Then section 308. Accused also will not come to your court, he will be in a designated place. 308. In a designated place through audio video means notified by the state government. This is 308. Then 309, no change. 316, subsection 4, one change. 316, subsection 4, one change. That is proviso. What it says, provided that the accused is in custody and is examined through electronic communication, signature shall be taken within 72 hours of such examination. We have discussed this already, I think. No? See, if a informant gives an electronic FIR communication, 3 days. Now it says, any deposition made by the accused, not physically, from the custody, a time limit of 72 hours is given. What will happen if it doesn't come after 72 hours, or if he come after 72 hours and explain some reasons? See, an informant gives a FIR through electronic means and goes to the police station on 4th day. Nothing will happen. You cannot throw the baby and the bath water also. Yes. Law says 3 days. It is, procedures are always for helping the people. Right? This you should not have it in 346. What? Adjournments. That is not for helping the people. Our people will know already how to help them for years together by dragging the cases. So, these 72 hours, that signature of FIR for 3 days, all this, if reasonable reasons are stated, it is excusable, because a man's right of lodging an FIR cannot be deprived by non-signing it within 3 or 4 days. So, that construction will defeat the purpose of law. Then 330, it is like 294G, but one provision is 30 days time is now added. 330 is like our 294. You cannot harass experts by calling them, right? One thing is, underline the word 30 days. If shall be called upon to admit or deny the genuineness of each such document soon after supply. This is like the Commercial Courts Act case. Documents should be verified by the parties and should be ascertained whether it is what? Genuine or not. If you deny the genuineness, you can call the expert, but you should say what is the fraudulent thing in that. Reasons. You cannot just for the drop of hat call experts. That is not the intention of 294 and it is not the intention of 330 also. See the proviso of 330, subsection 1 proviso last. Provided that no expert shall be called to appear before the court unless the report of such expert is disputed by any of the parties to the trial. And that dispute should not be in the air. It should have some profound reasons why you are disputing. One of the greatest headaches you will get rid of, 336. See, when examination 336, what is the greatest headache for all trial judges? No. Private parties, witnesses, police will somehow threaten and manage to produce. After the private parties are over, greatest headache, doctors, brake inspectors, investigating officers, all government officials. Because they have got other serious jobs to do. Because they are running the government. No. Cases are very small for them. Right? Now the greatest headache is you got rid of. Second headache is, first headache is to summon them. Second headache is to search them. Because a case of 1970 will come on 2020. You will search for the very same man or the man who is acquainted with his signature. You should only go and search all of them where? Either in the grave or hell or heaven, you do not know. Maker. Now, what is the provision? 336. It says, public officer, see, suppose Chandru was the public officer in 2000. Chandru has to be summoned. Previously, what you are doing? You are searching for Chandru. You are searching for some good friend of Chandru who knows the... now all this nonsense got stopped. Now who is occupying Chandru's seat? That fellow is the scapegoat. So it is very easy for you to send summons to the successor. That successor need not come to court physically. You can give him a leverage of appearing through. Suppose there is any agitation on the nature of documents or material dispute particular also, you can call him. But what this poor man will now come and say? I am talking from... He is a successor. He can only say that much. If you dispute or not dispute, it is your headache. Right? Or if the prosecution wants to rely upon them, it is for the prosecution to bring that man. Otherwise, court's headache is not there from 1st July 2024, at least for new cases. Because old cases are governed by old procedure. So, new recruits magistrates will be very happy. They will have only fresh cases. Oh, they will also have old case. My God, yes. Magistrates are new, cases are old. Huh? Yes. Old wine in a new case. So 336, please, prosecutors also please note 336. Your headache of searching also is not there. You just summon to the successor, that's all. (336) we have already dealt with. 336 has got how many teeth now? 2 teeth. 346. 346, adjournment has got a tooth. Previously, it was toothless. Okay. 349, I think I will not waste time in 349 because I have told this yesterday in detail. Voice sample and all other specimens, right? What was the case I told for voice sample? Ritesh Sinha versus State of UP 2019. What is the 11 bench case we discussed yesterday? 1961. 11 judges case. State of Bombay versus Kati Kallu Ogad. 1961. Okay. 11 judges. (349) is a comprehensive provision for ordering all sort of tests. Only one thing you cannot do, that is testimonial compulsion. What is testimonial compulsion? Sorry, what are the two types of succession? Testamentary? What is testamentary? If my father has got a will, Where will? Will in the mind. What he will do? Write a testament. This is called as testamentary succession. Now, testamentary compulsion cannot be done because of Article 23. What is testamentary this thing? Compulsion? It is compelling an accused to reveal something from his brain, mind. Otherwise, you can take every part of his body. You can take voice also from him. He cannot claim that it is violative of Article 20 subsection 3. Article 20 subsection 3 will guard him only from testamentary compulsion. You cannot compel him from the mind. Sir is asking for narco analysis. Write the judgment of Srimati Selvi versus State of Karnataka. 2010. Srimati Selvi versus State of Karnataka, 2010 Supreme Court, full bench. What was the decision in that? Whether prosecution or investigating agency can compel a person for 3 tests. What are they? 1 is polygraph test. 2 is beep test. 3 is narco analysis test. Polygraph, beep test, BEAP, beep test. 3rd is narco analysis. What is this beep test? BEAP, brain electrical amplification profile. Okay, brain electrical amplification profile. Whether these 3 tests can be undertaken by the investigating agency or not is the question raised in Srimati Selvi versus State of Karnataka. Supreme Court said you cannot do this because it is violative of Article 20 subsection 3. Supreme Court further said you can do this. Provided, now what they said, old man should not come to police station, he can come provided he wants to come. Like that, Supreme Court 2010 itself said, you should not do all this test because it is violative. Then they say it can be done provided he wills. You just imagine whether any fool will be willing to do that unless compelled by the police. Then Supreme Court said an accused can accept provided in the presence of his advocate and the judge. His advocate will be appointed by whom? See, when I am arrested by the police, in whose custody I am, whose mercy I am? Whatever police says, this fellow will nod the head. But in trial, he will say everything no. Right? Point 2 is, Supreme Court says, you can subject a person for all these 3 tests, provided he accepts it in the presence of his advocate before a magistrate. Then, test should not be conducted by police agency or investigating agency. Test has to be conducted by independent authorities, and the last rider is whatever is the result of the test, it should undergo the test of section 27 of IEA. You will take me, put me in a, what is that, stretcher like platform. In cinemas you have seen, no, one red carpet, yellow light, this fellow will be lying on that in a stretcher, all policemen in uniform, and one light will be going this side and that side, and injections will be put. This is called as narco analysis, right? In this narco analysis, the state says we can do that because it is not testimonial compulsion. See the beautiful argument. He says something out of non-compulsion because he is speaking on, CHANDRU will not speak after something goes inside. What will speak? Spirit will speak. Like that, narco analysis test, only that narcotics will speak. They said there is no compulsion, but court said you are instilling something on him, administering something on him, even if he says that he has committed a crime, still the test under section 27 of Evidence Act has to be passed. What is the test? Lead to discovery. Otherwise, all this exercise drama, it will go to, yes, you will not take the green pen and put 4 lines. Because no discovery, no admissible portion. Okay, I should finish. Both of you are standing and staring at me. I am getting scared. Okay, judges. We will meet if time permits. We are stopping at 3:49. Madam, now tell me, madam, whether I am Madras Express or... No, beyond that, I think if I rush, no, it will not serve the purpose, right? Okay. Two things. I apologize if at all I have hurted you in any way. That is one thing, right? Second is, yes, yes. No, beyond that, over and above that, if at all enthusiastically I have hurted you in any way, I plead apology. Second thing is, if at all I have erred in any law or fact, I will give my number, you can scold me. 98433. Yes. Yes. 98433 22533. 98433 22533. It is, my name is E.V. Chandru. 98433 22533. Okay. Two other things your director wants to talk on. One is section 356. Section 356 has to be read with. What is section 356? What is section 356? I have told you many times. I have told you inquiry, trial, judgments can be done in absentia. I have also told you it will be like a ex parte decree in a civil suit. Now, inquiry means, just 1 second. Yesterday we have seen one thing, when a trial commences. Trial commences after, what is the judgment? Hardeep Singh was a state of Punjab. So, any stage before trial is called as inquiry. So, any inquiry, any trial, every judgment can be proclaimed in the absence of that gentleman who is proclaimed offender. Who is proclaimed offender was defined in section 34, subsection 2, Roman 2. Right? How he should be declared as a proclaimed offender, I have told you it is in section 84. Exactly, very good. Attachment of property we have seen in super judge. You have given me a pass now. Right? You are repeating everything, that means that this teacher is not a failure. My senior, Pondicherry, no, my madam, my Mrs. Vrindamohan, she will say, Chandru, if they don't understand, if you teach and if anybody doesn't understand, you have failed. Right? That is my teacher. My teacher will say, if they don't understand it, they are not fools. She will not say like that. She will say, you have not taught them properly, you have failed. So, Karnataka people have proved that Chandru has not failed. Okay? Madam? Oh, thank you, madam. I touch your divine feet, madam. Madam has given me 100 marks. Then, secondly is, this 530-31. 530 we have seen, everything will become paperless. 531, simply understand that it is repeal and savings. 531 of BNSS is verbatim 484 of CRPC. So, the concept of whether new law will come, old law will come, investigation is governed under what, all these were already discussed under 484 by various high courts. I will give you two judgments, right? These two judgments are full bench judgments of the Gujarat High Court and one is Patna High Court. (531) is repeal and savings, right? You read these two judgments. One is Hiralal Nansa Bavasar, Hiralal Nansa Bavasar versus State of Gujarat, 1974, full bench Supreme Court. Another is Ram Bias Singh versus State of Bihar, Patna High Court. Ram Bias, B-E-Y-A-S. Ram Bias Singh versus State of Bihar Patna High Court, 1975 full bench. Okay. Now I will come to what is the difference in these two judgments. Hira Lal, please listen. Please listen 2 minutes. Because investigations which are pending, point 1, investigations which are pending will be governed by old law. Right? Trial which is pending will be governed by old law. Hiralal Nansabhavsar says, investigations pending will be governed by old law, charge sheet will be filed under new law. That is, new law means charge sheet will be filed under 193. Procedure under 193. Charge sheet will be filed under old, new law means not to new BNS. Right? No, new procedure. Charge sheets will be filed for pending this thing. If investigation is completed on 30th June, Hiralal Nansabhavsar says, investigation will be under the old act, charge sheet will be filed under 193 CRPC, because it says filing of charge sheet does not have anything to do with, it is not a continuation of investigation. This you please read Hiralal. One thing, yeah. Now, Hiralal Nansabhavsar also says, a man, we were discussing so many things about cognizance, right? One primary thing in cognizance is, the charge sheet says that CHANDRU has committed the offense of murder. Now, you as a judge, as a court, you take cognizance on the police report. What for? To summon me. Now, Hiralal Nansabhavsar says, on the date of taking cognizance, the accused accrues a right of defending him, and this defending him will continue up to the last stage. That is, see, I am repeating, you take cognizance of an offense on 30th July night. Right? CHANDRU goes to Supreme Court by 2050. After 20 years, 30 years. Hiralal Nansabhavsar says, a vested accrued right vests on the accused, not on the date of trial, not on the date of disposal of the trial court judgment. It gets initiated from the date of taking cognizance. An accused has an accrued vested right on the date of taking cognizance. Point 1. So, he will be governed by the law of the land on the date of cognizance. That means, cognizance followed by issuance of summons, followed by framing of charge, followed by trial, and Supreme, they say, Hiralal Nansabhavsar quoting Privy Council judgment and Garikapatti case. Garikapatti's case is a 5 judges bench case, which says every appeal is a continuation of suit, trial. Using that logic, extending that logic, so Hiralal Nansabhavsar says, irrespective of the fact whether trial has commenced, not commenced, what is the date of taking cognizance, that will be carried up to. They also say 484, the word used is trial disposed of. They are telling that, 3 judges bench is telling that disposal of trial means final disposal of trial through appeal or second appeal. This judgment of Hiralal Nansabhavsar is more convincing to me than Rambia's case. Rambias is telling, no, old law will govern the old proceedings. Trial will get completed under the old law. For appeal, if he has to come, he should come under the new law. This is what is said in Rambias. Here, Hiralal Nansabhavsar says, date of taking cognizance is the date to follow the procedure till final disposal. What G? Cognizance. You are taking cognizance on new. So new law. Yes, for taking cognizance. No, one second. Please. Honorable Judge is asking one question. Please let us clarify it. We have got 1 more minute. Okay. See, you should not confuse yourself with Article 20 subsection 1. What Article 20 subsection 1 says is doctrine of ex post facto laws. That is, criminal laws, penal laws will not be given retrospective effect. That means it is not an offense. See, CHANDRU is not feeding a beggar in my street, waiting in my house, in the front of the house. That man died. Doctor says he died out of starvation. CHANDRU cannot be implicated for any offense. A law comes tomorrow that non-feeding of a poor man is at least 304, death due to rational negligent act. Now, because of the new act, I cannot be punished for the old acts which I have committed. So, you should not confuse yourself with existing penal laws and the present penal laws, right? I have given my number. You can also note my email ID, but WhatsApp, there is a WhatsApp. Whatever doubt you have, please put it to me. I am not telling that I have got an horn. I know that I am lesser intelligent than you all. If you have a doubt, kindly tell me. If I do not know, I will ask with my senior or other good knowledgeable people. I will definitely let you know. Okay? evchandru@gmail.com. E for England, no, E for elephant. Let us not go for England. Parliament will, yes. Let us not go to British once again. V for victory, CHANDRU, evchandru@gmail.com, right? Thank you so much. I love you all. And one thing I repeat, any usefulness in the class, the merit, what is that? It goes only to my senior who taught me law. Thank you so much. Yes, you too love. Thank you.
Thank you so much, sir.
Thank you so much.
Well, it is said that the word thank you is such a prayer that cannot be seen or touched. It must be felt by heart. Our heartfelt thanks to you, sir, for your outstanding presentation on the subject. Your expertise and insights on the subject captivated us and left a long-lasting impression on us. All the sessions were interactive and it has benefited all of us in enhancing our knowledge on this subject. Can we all give a big round of applause once again to our sir? I, on behalf of Karnataka Judicial Academy and participants present here, express gratitude and extend warm thanks to you, sir. As a token of gratitude, we present a book to you, sir. Kindly accept. I request our Honorable Additional Director, sir, to hand over the book. Thank you so much, sir.
Going from Karnataka, no, I am going with heaps of love, loads of love, and also loads of food. Thank you.
With this, we conclude this session. Lunch is arranged in first and third floor. We'll rejoin by 3 p.m. for the next session. Thank you.